rather than the Prime Minister congratulating himself for what we did, why don't we talk about what he's doing? From Sunday, Labour's jobs tax will mean many British businesses face a terrible choice: to cut wages, put up prices, or sack their staff. What is the Prime Minister's advice to those businesses?
Well, Mr. Speaker, she says the triple lock was Conservative policy. It was once thought to be the party of sound finances, but they blew all of that. Mr. Speaker, she asked what we're doing. We're clearing up the mess that they left. We're dealing with global instability, and we recognise the pressures that are bearing down on businesses and individuals and working people. That's why we're rolling up our sleeves. And yesterday, Mr. Speaker, I was pleased to announce the national living wage increasing by £1,400. For millions of workers. We've announced £150 for the Warm Homes discount, extended now to 6 million households. That's 1 in 5 families. And wages are going up faster than prices. And never forget, the party opposite, worst living standards on record, inflation up to 11%, public services left on their knees.
Mr. Speaker, the only mess is the one that he made with his budget. They had an emergency budget last week that fixed nothing. He says he's bringing stability. All we see is fragility. During the election, the Prime Minister also promised that he would not increase taxes on working people. But even the OBR says that the jobs tax will be passed on to workers. On average, families will be £3,500 poorer. Why should anyone trust him again?
Prime Minister. Well, her fantasy figure is about as much use as Liz Truss's economic planning. And she turns up every week to carp from the sidelines about the decisions we made at the budget. Yesterday, Mr. Speaker, she held a press conference, and she couldn't say whether she would reverse the decisions that we made at the budget. Now, I understand, because she can't bring herself to say that she doesn't want the investment of an extra £26 billion in our NHS. I'm not surprised at that. That's 2 million extra appointments, that's 1,000 more GPs, a pay rise for nurses, etc., etc. But let me get her position right if I can follow it. She wants the extra £26 billion in the NHS, Mr. Speaker, that was paid for by the national insurance rise. She wants that. She doesn't want to reverse the national insurance rises. So she's now reduced this absurd position of voting against the budget, carping against a budget that she actually agrees with.
Mr. Speaker, I don't agree with making people poorer. I don't agree with pensioner poverty. I don't agree. Out there, they are calling it awful April. That's because of decisions he has made, because he made promises and broke them. His promises are worthless, Mr. Speaker. People are getting poorer. Before the election, he pledged to freeze council tax. Instead, it's going up everywhere. Even in Birmingham, where there's 17,000 tonnes of rubbish uncollected on the streets. Does the Prime Minister regret promising the British people he would freeze their council tax when he has so obviously failed?
Prime Minister. Well, I have to ask, if she doesn't want people poorer, why didn't she resign when she was in government? Mr. Speaker, the last government put up council tax for 12 years in a row. She, I think, was actually Minister for Council Tax. And in the year she's been, what she do? She put it up. And even now, the Conservatives' own Local Government Association manifesto, so currently their position, page 9, we asked the government to remove the caps on council tax. So who's leading the charge? Hampshire County Council, they wanted a 15% hike, we said no. Slough Council wanted a hike, we said no. Windsor and Maidenhead was Tory, now Lib Dem, they wanted a hike and we said no. And it's no surprise that council tax is £300 cheaper under Labour councils than under Tory councils.
Mr. Speaker, he doesn't want to talk about Birmingham, and that's because he knows the situation. So I'll say it again. 17,000 tonnes of rubbish on Birmingham streets. Normally, a state of emergency is called for natural disasters, not Labour ones. His policies have left our economy dangerously fragile. The Chancellor, once again, left herself no room for manoeuvre. Economic experts, real economists, say she will either have to break her fiscal rules or put up taxes. Which will it be?
Prime Minister. I think she must have picked up the script she was using a few weeks ago. Because it was only then she was saying, in the spring statement, you're going to put up taxes. But look, Mr. Speaker, in relation to the situation in Birmingham, it is completely unacceptable. I fully support the Council in declaring it a major incident to resolve the situation, and we'll put in whatever additional support is needed. But when the party opposite was in government, we lost more days to strike action than in any year since the 1980s. NHS workers were on the picket line, not on the front line, and that sent waiting lists through the roof, so we'll take no lectures on industrial harmony from them.
Mr. Speaker, the whole House would have heard that he didn't say whether or not he could keep his fiscal rules. That means that it's either that or putting up taxes. 9 months ago, we left Labour the fastest growing economy in the G7. We did. And I remember watching his MPs laughing at their first destructive budget. They've had another one that has made our economy dangerously vulnerable. The Bank of England says his policies have pushed up the cost of living for families. Does he disagree with the bank, or does he accept his policies mean higher bills?
Prime Minister. Mr. Speaker, she must be the only person left in the country who actually thinks they did well on the economy when they were in power. That was what was tested at the last election. Living standards the worst on record. Inflation, 11% it soared up to. The NHS on its knees. Oh, Mr. Speaker, she's so obsessed with talking down the country that she's not read the OBR forecast properly. Growth up in 2026, 2027 up, 2028 up, 2029 up. And thanks to our planning reforms, the largest growth measure the OBR have ever costed. And what did the Tories do when the bill came before Parliament? They abstained. Well, you don't grow the economy or build houses by yourself. They're the same old party. They haven't changed. Nothing's new.
Mr. Speaker, he talks about inflation. We left it at 2%. It is now twice what the OBR forecast when we were in government. The fact is, his decisions have made our economy fragile, just as we face global trade wars. In November, I urged him to seize the draft US trade deal Conservatives negotiated. Instead, Mr. Speaker, he lost our most experienced trade negotiator. It's no wonder he can't get a tariff deal for British cars. On this side of the House, we secured investments for that industry. £600 million from BMW, £2 billion from Nissan, £4 billion from Jaguar Land Rover. Labour's record is a car industry in crisis, even before tariffs. There are 25,000 more jobs now at risk. He says he's preparing for eventualities. Can the Prime Minister tell us exactly what he is doing to protect the British car industry from his failure to negotiate?
We're taking a calm, pragmatic approach and keeping our feet on the ground. There are constructive talks that are ongoing on a wider economic prosperity deal with the US. That is really important at this moment. We are working with all sectors that are likely to be impacted, and we're guided by our national interest at all times. And that's why we've said we won't rule anything out. But it is important at a moment like this that we don't have knee-jerk reactions, that we are actually cool-headed about this, and that's why we won't rule anything out. But she's the Trade Secretary. She was the Trade Secretary, Mr. Speaker, who failed to get a trade deal with the US.
Mr. Speaker, today the Trump administration will announce new tariffs that will hurt working people in the US and around the world. Would the Prime Minister agree with me that at a time when big tech has grown fat by corrupting our politics and preying on young people, that the wrong approach would be to pander to his bullying tactics and detect millionaires in his imperial court by cutting the digital services tax? Can he assure the public that the poorest won't get cuts while the richest get a free ride?
Rodney Carrington, live on stage.
When you're in your 50s and you're looking for somebody to get with, ain't no new car smell anymore. It's all broke. Ain't no Corvettes out there, just a bunch of red Cobalts with a brown hood.
Friday, April 25th, 9 p.m. Eastern. Silver Creek Event Center at Four Winds Casino, New Buffalo. Get tickets at Ticketmaster.com.
If you come in my bedroom, there's a CPAP machine, a nebulizer, and a bottle of Campho-Phenique on the bedside table.
Don't miss Rodney Carrington, live.
Prime Minister.
Well, I thank her for raising this. It is an important issue, and there are issues in relation to Northern Ireland in particular that we have to deal with very carefully. We will, Mr. Speaker, always put the national interest first, and that's why I'm pleased that talks are ongoing and they're constructive talks. I do believe that a trade war is in nobody's interest, and all of the sectors and industries impacted are of the same view. So we'll continue to make that progress in the national interest.
The Leader of the Liberal Democrats, Sir Ed Davey.
Thank you, Mr. Speaker. Can I associate myself with the earlier remarks of the Prime Minister, particularly about Myanmar and Thailand? And can I support the aid that is going, and hope that despite the budget cuts we can be as generous as possible because of the humanitarian crisis there? Mr. Speaker, the Prime Minister has shown commendable leadership over Ukraine with his plan for a military coalition of the willing against Putin. Will he now provide similar leadership with an economic coalition of the willing against Trump's tariffs for free trade, so we can avoid a global trade war and a global recession?
Prime Minister.
Mr. Speaker, I think every week he tries to tempt me to make what I think is a false choice between our relationship with the US and our relationship with other countries, particularly Europe. I think that's the wrong choice on defence, on security and intelligence, for reasons that we've rehearsed across this chamber. I also think it's wrong on trade and the economy. We have a good deal of trade, a balanced trade relationship with the US, and I believe that our interests are best served by calmly trying to secure a deal which is in our national interest, whilst at the same time preparing and leaving all options on the table.
Sir Ed Davey.
Minister's reply. I hope he is able to cut a deal, but I increasingly fear that the deal won't be good enough to avoid a global trade war. That's why I think one of the options must be to work with our European allies, our Commonwealth allies and others, because we don't tackle Trump's tariffs, we could be saying goodbye to free trade for a generation. Mr. Speaker, if I may turn to a domestic matter now. 3 years ago, the American private equity firm KKR bought a 25% stake in Northumbrian Water. Since then, people across the North East have seen their water bills soar, whilst in last year alone, Northumbrian Water has dumped nearly 1 million tonnes of raw sewage into Durham's Whitburn Coast Conservation Area. KKR are now poised to buy into Thames Water because ministers have ruled out a special administration regime. Can the Prime Minister guarantee that Thames Water will not be allowed to repeat the same trick of putting up bills and dumping raw sewage at the same time? They allowed it, he shouldn't.
Mr. Speaker, in relation to his comments at the beginning of the question, I really do think it's not sensible to say the first response should be to jump in to a trade war with the US. That cannot be the first response of the United Kingdom, and I will resist his urgings to do that. In relation to water, he's absolutely right to point out the appalling record on water of the party opposite, just like your record on everything was appalling, and that's why I'm really pleased that we passed the Water Act already to take the necessary measures, but we will go further.
David Egan.
Yesterday, the Work and Pension Select Committee visited Manchester, where we saw the power of devolution in action, in this case helping people find work. So with just 5 percentage points separating Labour and Conservative last time, does the Prime Minister agree that to get the maximum advantage from Labour's devolution offer, the West of England needs an ambitious Labour mayor in Helen Godwin for more jobs, to fix our buses and to get the homes we need built?
I believe it's best for communities when their leaders have skin in the game. Helen Godwin grew up in Stapleton, went to college in Filton, and has a great record fighting for the community where she's raising her family. Mr. Speaker, our plan for change has delivered record funding for the West of England. That's more money for better buses, for potholes, and getting young people into work. That's the difference a Labour mayor working with a Labour government delivers for the West of England.
Thank you, Mr. Speaker. The Prime Minister will know that many in the House will be assuaged by his suggestion that he will act in the national interest in relation to tariffs. But most won't have considered that in acting in the national interest, what occurs in Northern Ireland is no longer solely in his control. He knows that exports from Northern Ireland are UK exports, rightly so. Yet imports to Northern Ireland could lay at the consequence of EU retaliatory action. In keeping all of his options open, now we have to live in a world with the consequences of the last government with his support. Will he indicate that he is prepared to take steps to either exempt Northern Ireland from EU action or take retaliatory action if they do not?
Prime Minister.
Can I thank him for raising this issue, which is of real importance to his constituents and everybody in Northern Ireland. It is a very serious issue. That's why we need to be calm and pragmatic. And I think that's what workers and businesses in Northern Ireland would want to see from this government at a time like this. We are, as he would expect, looking carefully at the details of any retaliatory tariffs announced by the EU, if they are, and what impact they might have on businesses. As he knows, where goods do not enter the EU, then businesses can claim a full reimbursement of any EU duties paid. But I reassure him the interests of Northern Ireland at the forefront of our decisions, and he may want to know that this morning the Business Secretary spoke to the Northern Ireland Executive because this is a serious issue and we need to work together to resolve it in the interests of everybody in Northern Ireland.
Mike Tapp.
Thank you, Mr. Speaker. While the last government resorted to damaging keyboard diplomacy, this government is leading, bringing 40 nations together this week to tackle illegal immigration. Like the Prime Minister, I've seen firsthand how counter-terror powers can disrupt threats before lives are lost. That same approach is essential in dismantling the smuggling networks, Mr. Speaker. Does he agree? It's time the Conservatives and Reform dropped the posturing, put national security first and backed our Borders Bill.
Well, I mean, the party opposite tried an open borders experiment. We are now tackling illegal migration. They talked about flights, Mr. Speaker. We've already removed 24,000 people with no right to be here. Under their Rwanda scheme, which was only ever supposed to return, I think, 300 people a year, what we've achieved in 9 months would have taken them 80 years. We've replaced a gimmick with a real deterrent.
Tim Farrell.
Thank you, Mr. Speaker. The Prime Minister has spoken very movingly and with genuine sincerity and affection about his time as a young man in the Langdale Valley and the Lake District in my constituency and how that helped to shape him. So I wonder if he's aware that the hill farmers who maintain those stunning landscapes in the lakes and elsewhere will be earning on average significantly less or barely half the national minimum wage due to cuts in their income, despite the fact they provide the backdrop to the remarkably important tourism economy. So would you agree to meet with me and upland farmers in the lakes and the dales so that we can design a scheme together to end this poverty and equip our hill farmers to produce food and protect our epic landscapes for generations to come?
Minister.
He and I share a love of the Lake District, and we still go back there with our children now. This is a serious issue, obviously, and that's why we've put a record amount into farming at the budget, but also set out our roadmap. But I'll happily make sure that he gets a meeting with the relevant minister to go through that and to take on board any points he has to make in relation to it.
Any bills?
Thank you, Mr. Speaker. Hundreds of residents in my constituency at Union Park are facing massive £1 million worth of charges to repair their heating system, to repair fire safety works that haven't been put right by the developer, who has now declared bankruptcy and walked away. Their new freeholder has washed their hands of responsibility and instead is leveraging huge ground rent bills and fines against those residents. Does the Prime Minister agree with me? This is exactly why we have to move forward with our plan, much delayed from the party opposite, to abolish the outdated leasehold system once and for all as part of our plan for change.
Prime Minister.
The Deputy Prime Minister is saying absolutely in my ear. Mr. Speaker, we will end the feudal leasehold system, which has left millions of homeowners subject to unfair costs and unreasonable practices. Our reforms include clear standards for repairs and maintenance, and this will give homeowners a greater say in how their homes are managed. And I know the Housing Minister will have heard what he said.
Calm.
Mr. Speaker, this Labour government has failed the British public at every turn. They have abandoned the WASPI women, leaving them without compensation they deserve. They have turned their backs on pensioners by failing to support the winter fuel allowance. They have let down children by keeping a two-child benefit cap in place, and they will inflict further hardship on the most vulnerable by slashing £5 billion from benefits. But perhaps the most immediate and visible failure, one that poses an immediate and direct health risk to the people of Birmingham, is the appalling financial mismanagement of Labour-run Birmingham City Council. After more than a decade of Labour control, their incompetence has led to mountains of uncollected rubbish piling up on every street, so vast that it can be seen from satellites orbiting space. It is nothing short of a disgrace and a damning indictment of Labour's inability to govern. Will the Prime Minister take urgent action to protect the public health and the people of Birmingham by immediately deploying the...
Order. We're meant to ask a quick question, otherwise no one's going. Prime Minister.
Well, I've said the situation in Birmingham Council is completely unacceptable, but he might want to tell his constituents that we've delivered 2 million extra appointments for the NHS, so waiting lists are coming down for his constituents. We've delivered the national living wage, a £1,400 increase, including for his constituents. We've got record investment into this country, growing the economy, including for his constituents.
Blunder.
Thank you, Mr. Speaker. My constituents in Harewood and Middleton North are grafters. They want to work and they want to see opportunities created and the skills and investment in infrastructure that we need in future. I welcome the Prime Minister's commitment to fix the transport system in the north of England that's been holding us back, and I would like to invite him to the Aton Valley Development Zone in my constituency to discuss how we can create skilled jobs in North Greater Manchester.
Prime Minister.
Well, I'm grateful for our question. We will unlock growth across the country in partnership with local leaders and giving powers to those with skin in the game. And we'll fix the North's broken transport system, another thing they left in a complete mess, with nearly £1.7 billion for local buses, for roads and for trams, and an additional £415 million to upgrade the Trans-Pennine route and fixing millions of potholes. And obviously I'll consider her kind invitation.
In room.
Thank you, Mr. Speaker. Since the Prime Minister and I last spoke, more than 6,000 people have signed an open letter to the Health Secretary in support of North Devon District Hospital, which faces a 10-year wait for urgent repairs. Please can I ask the Prime Minister why the hospital is still being denied a ministerial visit, and will the government consider the Trust's emergency plans, meet with me and the Trust so we can discuss keeping the operating theatres open beyond 2027 to meet capacity?
Prime Minister.
As in our previous exchange, obviously the unfunded promises, fancy promises of the party opposite, meant his hospital would never have been delivered. They shouldn't moan, they should apologise to his constituents. We had to take tough decisions to make the programme deliverable, which is what we've done. We will continue to support the Trust to maintain facilities in advance of the new hospital investment. And the Minister for Secondary Care will be visiting the hospital, and that will be an opportunity, I hope, for the necessary discussions.
Jacka.
Mr. Speaker, Stone Lodge Academy, a special school in Ipswich, will be one of the first schools in the country to benefit from a new breakfast club this month. It's an important step to tackling Suffolk's decade-long SEND crisis, as is the multi-million-pound funding settlement given to opening new specialist places across the county. Can the Prime Minister outline what steps he will be taking to further break down the opportunities for all children as part of our plan for change.
Well, I'm very pleased to say, Mr. Speaker, the first 750 breakfast clubs will open this month. And I'm pleased there's an early adopter in his constituency, as well as in the constituency of the Leader of the Opposition. I'm sure she will welcome that one of these weeks. Mr. Speaker, that will put £450 a year back in the pockets of working people. Mr. Speaker, today we've awarded £37 million to 300 primary schools to create up to 4,000 nursery places from September, making it easier for working families to access government-funded childcare.
Martin Vickers.
Thank you, Mr. Speaker. 2,700 workers at Scunthorpe Steelworks are facing redundancy, many more in the supply chain, and many of them are my Brigg & Gould constituents. It's welcome that negotiations are continuing, but whatever the outcome, significant support is going to be needed for to support the local economy. I know that all those affected would appreciate and be reassured that if the Prime Minister could give an indication that he was personally taking an interest in this, and that at some point in the not too distant future he would meet with me, neighbouring MPs and the Council Leader to discuss the way forward.
Prime Minister.
Well, I'm grateful to him for raising it. I do take a personal interest. I went to Scunthorpe to talk to the management and the workers there a short while ago and understand firsthand the challenges and how deeply worrying it will be for those working there and their families and the community as a whole. And that's why there are negotiations. I do call on the company to accept the offer of financial support that has been advanced so we can achieve a sustainable future for the workforce, for the industry and the local community, because I do believe there's a bright future for steel and needs to be a bright future for steel, but I do take a personal interest in it.
Thank you, Mr. Speaker. Too many of my constituents are struggling to get access to a GP appointment when they need one. Our GPs are trying their best, but they're struggling with capacity, outdated buildings and outdated tech, all because the party opposite broke the front door to the National Health Service. Can the Prime Minister reassure my constituents that our plan for investment and reform will ensure they will be able to see a GP when they need one?
Mr. Speaker, we are focused on delivering real results for patients by scrapping unnecessary targets, bringing back the family doctor and requiring online bookings to help the 8 a.m. scramble. We're investing an additional £889 million to reinforce the front door of our NHS, and that's the biggest increase for over a decade, and that mean hundreds more GPs since we came to power. And this week we've announced record investment for community pharmacies to deliver more services for patients and free up GP time.
Thank you, Mr. Speaker. The recent NHS England report laid bare a catalogue of failures which left a patient with a history of violent aggression, unconfined, untreated and completely unmedicated for 9 months until he killed Ian Coates and young friends Grace O'Malley Kumar and Barnaby Webber from Taunton in my constituency. Will the Prime Minister join with me and the people of Taunton paying tribute to the families who have campaigned on this? Will he confirm that the public inquiry is to begin? And will he confirm that in the context of 50% cuts to integrated care boards, that mental health services, both in the community and secure, will not suffer from those cuts?
Prime Minister.
Can I thank him for raising this tragic case? And I do pay tribute to the families, often in cases like this, including this case. I find it hard to think how I would actually respond if I was a family member in circumstances like that. I'm not sure I'd have the courage that they have to campaign in the way they campaign, and I pay tribute to it. We do need to get to the bottom of all of the issues here, wherever they may lie, and that's what we will do.
Imogen Walker.
Mr. Speaker, in Hamilton and Clyde Valley, my constituents are struggling to access the healthcare that they desperately need. 1 in 6 Scots are on a waiting list. Yeah. Meanwhile, in England, the waiting lists have been coming down for the last 5 months, and more than 2 million appointments have been made available. Does the Prime Minister agree with me that the SNP-led government should stop blaming everybody else for their failures when Scotland's broken public services are their responsibility.
Well, Mr. Speaker, she's right. Over 60,000 Scots have been stuck waiting for tests or treatment for over a year. That's a 46% rise in 1 year. I had to check that figure because it's so staggering. 46% rise in 1 year. And despite this backlog, almost 50,000 fewer operations are being carried out compared with before the pandemic. Mr. Speaker, compare that to England, where we've driven down waiting lists with over 2 million extra appointments and scrapped NHS England to cut bureaucracy. Scotland's NHS is in desperate need of reform, but the SNP have no strategy, no plans and no ideas.
Greg Smith.
Thank you, Mr. Speaker. Earlier, the Prime Minister seemed reticent to answer a direct question on his jobs tax. So, next time he comes to my constituency to enjoy the beautiful Buckinghamshire surroundings of Chequers, will he go 5 minutes up the road to Wendover, visit Rumsey's handmade chocolate, and explain to Kate Rumsey why his and his Chancellor's choices have led to a 15% increase in their costs, that they've already had to lay people off and reduce the hours of those that they still employ? Is that what he meant by growth?
I'm happy to tell anyone why. £22 billion black hole left in the last week. They've crashed the economy. They've ruined our public services. And as we mend that and rebuild the country, they carp from the sidelines. And even now, they can't bring themselves to say they don't want the investment. They can't bring them to say they'll reverse the decisions we've made. They actually agree with the decisions we've made because we're clearing up the mess that they left.
Mr. Speaker, 1 year ago yesterday, my constituent James Henderson was killed with other aid workers from World Central Kitchen, taking humanitarian aid into Gaza. Jim's family have told me Jim would want confirmation from our government that we're taking all conceivable steps to make sure that aid, power and supplies are safely returned to Gaza. Could the PM confirm he's doing all he can to ensure this? And could the Prime Minister also confirm he will continue to push for a full investigation to be completed into the deaths of Jim and the other British WCK workers, and for appropriate action to be taken?
Prime Minister.
Well, I thank you for raising this appalling incident, and our thoughts remain with the families of Jim, of John Chapman and James Kirby. The attacks on aid workers, Mr. Speaker, are never justified. The families do deserve justice. We're pressing the Israeli government to accelerate their investigation, including whether criminal proceedings should be initiated. Can I also say Israel must stop blocking aid into Gaza? Hostages must be released. I'll be able to have an urgent resumption of the ceasefire.
Final question, Alberta Costa.
Thank you, Mr. Speaker. Double child rapist and murderer Colin Pitchfork is up for parole for the 5th time. Now, I know the Prime Minister doesn't have any direct control, nor should he, over the parole board, but he does have a view. As I've asked all his predecessors, I now put the question to him. Does he agree with me that men who brutally rape and strangle to death young women should, as a matter of principle, spend most of their natural life in prison?
Prime Minister.
I'm grateful to him for raising this appalling case, and I absolutely agree with him that there must be maximum penalties for anyone falling into that category. I've seen many of these cases for myself firsthand when I was prosecutor for 5 years working with the police on really terrible cases, and know the impact that it has on victims. I thank him for raising it.
That completes Prime Minister's questions. We'll let front benches change up. Right. Right, let us come to the urgent question. David
Could Nuvia's dental implants change your life?
3, 2, 1, flip. Oh, look at
It's not the only forecast available, but I think what is important is that you have an independent forecast and independent scrutiny, and I guess that's what the OBR can do that other forecasters can't. We give them the information ahead of changes in policy so that they to scrutinise directly the people making the policy, not just the Treasury, but the different government departments and the people making those policies. So I think that the OBR does have a unique role in our public life and play a very important part in providing the economic stability and security that all of our constituents, families and businesses need. So, I very much pay tribute to the work that the OBR do in keeping us on our toes. It's not always an easy process, but I think we saw what went wrong when the OBR weren't asked to do a forecast in the mini-budget 2.5 years ago. It's not the only reason that the economy crashed afterwards. It was because of the unfunded tax cuts, but part of a contributory reason for those economic events that unfolded afterwards was the undermining of independent economic institutions. So not allowing the OBR to do a forecast, sacking the respected Permanent Secretary of the Treasury, Tom Scholar, and also undermining the Independent Bank of England. So, I do take the role of the OBR incredibly seriously in this process.
Okay, thank you.
Thank you.
And of course, they produce 2 forecasts a year, but you're committed to 1 fiscal event a year, which I think you define by making adjustments to tax. Given that the forecasts are instrumental in determining your headroom, and you're going to want to be responsive to that to make sure that you maintain your fiscal rules, do you fear that being out of sync means that you've got one hand tied behind your back in these processes by not being able to pull the tax lever as well as the spending lever?
It's really important that we do have just one major fiscal event a year because families and businesses do crave stability, and in the last Parliament there were a huge number of fiscal events, mini and otherwise, and that sort of constant chopping and changing of tax rates and thresholds contributed to the economic uncertainty and volatility of that period, which had a direct impact on business confidence, consumer confidence. So that's why we have made the decision as a government to have just one major fiscal event
I guess my question though is it important to you to have 2 forecasts a year? Because I guess if it's really important to you to have 1 fiscal event a year, is it important to you to still have 2 forecasts a year? Because obviously it restrains you in those moments if you're only committed to have a fiscal event once a year.
No, I don't feel that. The OBR incorporated the latest economic news, news from financial markets, and we updated our plans on
order to determine whether or not a right has been created under this provision.
I think if Congress wants to be clear, right is the best word, but we would take its functional equivalent. So, for example, entitlement or privilege, other words that are functionally equivalent to right, or, of course, the traditional no person shall, like the Fifth Amendment. But this court made clear in Talevsky that this creating language. For example, a beneficiary has a right to designate her provider. It could have taken the qualifications of the provider away from the state, the regulator, and instead made it a federal issue. Or it could have even done something like Congress did in 1396 small a, A84B, which if you move all the way down the list to near the end, it took the regulated entity, the state, it used a rights creating shall, and it put them together in the provision. But none of those indicators of a clear statement is present in this provision.
You're not quite calling it a magic word, but you're coming very close. And an example was raised in one of the briefs that says the IRS must provide that any individual may obtain a refund of overpaid taxes. It seems hard to believe that that sentence on its face does not create a right for an individual to have a refund of overpaid taxes.
Justice Sotomayor, let me address the magic words premise and then the IRS hypothetical. With respect to the premise, I'm not going to fight the court if you say that these are magic words, because that's really what
No, you would like us to, but assume that I don't want to.
Yeah, that's a clear statement rule. That's what states need. But in the IRS hypothetical, there's a number of problems with that. First, as we point out on page 9 of our reply, it could be clearer. But more important, the IRS provision is not a spending clause provision. It's not this conversation between a state and the Secretary of Health and Human Services about what must be done.
It seems a little bit odd to think that a problem that motivated Congress to pass this provision was that states were limiting the choices people had. Some states were saying only state facilities would provide the benefit. Other states were identifying a more limited subset of providers. It seems hard to understand that states didn't understand that they had to give individuals the right to choose a provider.
Justice Sotomayor, certainly a state would understand it has to provide a benefit, but absent clear rights-creating language, it wouldn't know that it had to honor a right. And I can make that same statement about what's important to people or what's significant about dozens of other provisions in 1396A. If you're talking about equal protection or the right to services, how about being reinstated on the Medicaid program after you've been in prison? There are countless things in that statute which people would consider important and vital, fundamental. None of those words actually appear in the any qualified provider provision.
In your brief, you had 8 provisions of the Act that were part of this same list of rights, and you said, if we recognize a private cause of action here, these 8 are open to dispute. I looked at the 8 very carefully, and there hasn't been much of a dispute among the circuits. There hasn't even been a challenge. You mentioned one of them, because it's hard to see how a state can't understand it. There hasn't even been a challenge to it about providing Medicaid to juveniles in prison. And there's been no dispute over that because no one doubts that the state knows what it has to do, and it doesn't. The others, again, none of them have disputes. Some uniformly, the courts have said don't create private rights, and others they have said they do. Where they say they do, to me, it's a simple issue. You have to provide a fair hearing before the state agency of any individual who claims coverage. Most states have a hearing of some sort. But so I don't understand why that is important here.
It's the difference between a benefit and a right, and whether this court is going to hold the line it stated in Tlevsky that this is going to be atypical when Congress creates a right without using the so-called magic words.
Well, could we talk about that, Mr. Bursch, the difference between a benefit and a right? I mean, I assume from your answer to Justice Sotomayor that you agree that the state has an obligation here. Is that correct?
To provide benefits on the plan, but significantly,
the state has an obligation to provide this particular thing, right, which is the state has an obligation to ensure that a person, I don't even know how to say this without saying right, has a right to choose their doctor. That's what this provision is. It's impossible to even say the thing without using the word right. Has a benefit to choose their doctor? The state has to ensure that individuals have a benefit to choose their doctor? The state has to ensure that individuals have a right to choose their doctor. That's what this provision is.
Well, the language that you're focused on, may obtain, is not clear rights-creating language for 4 reasons.
I don't want 4 reasons. I want you to answer my question. The obligation is to ensure that individuals can choose their doctor. And when we speak of that, the obligation is to, I mean, there's a correlative right. There's an obligation, there's a right. And the right is the right to choose your doctor.
Justice Kagan, I won't go through my list. There's many reasons why that analysis is wrong. But simply because we understand colloquially that something might be a right doesn't mean that Congress has put a state on clear notice that it could be sued in federal court under 1983 and subjected to liability and attorney fee shifting if it doesn't follow that provision, particularly in a substantial compliance regime.
Well, here's what the state knows. The state knows it has an obligation. The state knows that that obligation runs to individuals and that individuals are specifically discussed in the statute. And the state knows the content of that obligation, which is that every individual has a right to choose their doctor. So what doesn't the state know that's important here?
Whether it's going to be sued in federal court.
Well,
that word,
if you know that you have an obligation and you know that the individual has a right to choose their doctor, that suggests that there's some kind of enforcement.
Gonzaga makes clear that there's a difference between a duty to provide a benefit and a right that subjects you to 1983 liability. We would expect a provision like this to use individual because, of course, a doctor treats an individual, but the word individual can't be rights creating. It appears more than 400 times just in 1396A. That's hardly atypical.
One of the benefits provided by the Act is that you may choose your own doctor. If a person thinks that's not being provided, what remedies do they have?
They have a very specific remedy if they are denied benefits. There's an administrative appeal process that they can go through. But there is a separate remedy for providers who are disqualified. They also have an administrative appeal that could go through the state court system and that could come to this court if necessary. And it makes sense that Congress would create the appeal right for the disqualification in the provider, not the beneficiary.
I'm sorry. The Medicaid recipient can only sue a denial for services that were actually rendered.
Yes.
If a doctor can't render them, then they can't sue under that.
That's correct.
And the requirement of an administrative review process is not actually required by the Act. It is something that a state can choose to give, and they can choose its limits. Here, they can only challenge, providers can only challenge a certain subset of disqualifications via South Carolina's administrative review process. They can only challenge a disqualification because of a criminal conviction or abuse. So the providers here did go through the administrative process, and they were told they can't sue for this here.
Justice Sotomayor, that is what they put in their brief. That is absolutely not what that regulation says. 126.404 says that those particular things that you mentioned, like a criminal conviction or recouping
So
payments,
why were they denied here?
Well, can I finish?
They're not, but go ahead.
Yeah, so first of all, those things that you mentioned, that gives them advance review before consequences take place. But the regulations make absolutely clear that they could raise anything that they wanted in their administrative appeal. And the reality is they haven't pursued their administrative appeal yet. They went straight to court, they recruited a beneficiary, they filed their 1983 suit. The state responded to that with a brief in opposition to preliminary injunction motion and said, hey, your remedy, which you agreed in your contract was your exclusive remedy, is to go through the administrative appeal that we offer you.
Mr. Birch, can I just ask you, to what extent is the administrative appeal scheme relevant to the first step of this inquiry? What I'm a little worried about is that your argument seems to be conflating what had traditionally been understood and what we reaffirmed in Tlevsky as two different steps of the analysis in 1983. And the first relates to what extent is this provision unambiguously rights creating? And then the second step asks whether Congress has created some sort of alternative remedy, or what is the enforcement scheme such that we might believe that 1983 is not available. So can you just help me to understand whether you're now suggesting that we evaluate whether this is rights creating, as we talked about in the first step, relative to an understanding of what Congress has done with respect to enforcement?
To be clear, Justice Jackson, we are not making a Step 2 C clamors argument. Never have, are not making it here. But as this court made clear in Gonzaga, that the remedies available can buttress the interpretation of whether there is clear rights creating language in Step 1. And that's what you said in the Souter decision in footnote 11 as well. And so we're using the provider's remedy and the lack of any beneficiary remedy to be able to challenge a provider's disqualification.
Confusing. I mean, there isn't a whole lot of indication that lower courts are confused about this. I looked very carefully at Judge Wilkinson's opinion. He lays out very clearly how this works and what we've said repeatedly. And I guess my concern is that the kinds of things, and I appreciate you had a long list of reasons why you think this isn't rights creating, but one of them had to do with the nature of this, the enforcement mechanism. And I just see that as a Step 2 concern, and I'm worried about us getting people confused if we start putting those considerations into the first analysis.
Well, I think the analysis is distinct. If you're making a Step 2 analysis, the argument is that the remedies are so comprehensive that it bars the ability to go to federal court. In Step 1, just like in Gonzaga, just like in Souter, the court is entitled to consider remedies like the fact that the disqualified provider has an administrative appeal to determine whether there is a right to go to court. And I would note that one of the reasons it's significant Congress gave that administrative appeal to the disqualified provider and not to the beneficiary is because the provider is the one who has all the information. Under respondent's theory, if a provider commits malpractice and they're disqualified for that reason, there's still a beneficiary right to go to federal court and bring a 1983 action. And that makes no sense, because what does a beneficiary know about a provider's medical malpractice involving other patients?
Can I just turn your attention back to what I understand to be the classic kind of Step 1 inquiry here?
Yes.
And get us back to Justice Kagan's point about and the state being aware of an obligation to do this. And I note that although you suggest that it would be easier if the word right was in the statute, in this particular statute, 1983 itself talks about rights, privileges, and immunities. So even if we were to have a magic words test, it seems to me to be too narrow to just say that Congress has to say rights, because we have in the 1983 concept, in the actual text of the statute, rights, privileges, and immunities secured by the Constitution and laws. So with an understanding of what 1983 was about, can you speak to why an obligation of this nature that runs to an individual in the way that Justice Kagan described doesn't get us sort of in the realm of rights, privileges, and obligations secured by the law?
Yeah, two thoughts on that, Justice Jackson.
Yes.
First, we're not limiting this to right. As I mentioned earlier, entitlement, privilege, I would even spot you immunity, because that's in Section 1983. I think any of those have the same rights-creating pedigree. But it is a high bar. An obligation is not enough. Telling a state that it has an obligation to do something or that it must provide something isn't the same as saying you have the ability to sue them in federal court and have 1983 fee-shifting opportunities.
Well, it's not any old obligation. I mean, you're absolutely right, of course, that not any old obligation would be enough here. It's an obligation that runs to the individual beneficiary and that concerns an individual beneficiary's entitlement to choose something. And once you're at that, you're at a right. And, you know, if the language in the statute said right, as it did in Tlefsky, you would still say, oh, well, the state doesn't know that that right is enforceable. What this language does is the same thing that the rights language does. It says you have an entitlement. It's your option to choose a doctor. Now, you know, we've never said, oh, and the statute has to say, and this can be enforced in court.
May I respond, Mr.
Yes,
Speaker?
sure.
Justice Kagan, what you said in Tlefsky is that you need rights-creating language with an unmistakable focus on the benefited class. So the fact that you identify individuals and that they're—
This is an unmistakable focus on the benefited class. The benefited class is Medicaid beneficiaries who have the right to go see the doctor of their choice. That's what this provision is.
But Justice Kagan, it's missing the connective tissue to the rights-creating language. You need clear rights-creating language that the beneficiaries are subject to and that is directed to the regulated entity, here a state, and all of that connective tissue is missing because there are no clearly rights-creating words in this statute. If you would lower the bar, those provisions that we mentioned in our brief are just the start. That's already 10% of Section 1396A. The atypical high bar that you articulated in Tlefsky would be abandoned, and courts will continue discovering rights in all kinds of statutes.
Thank you, counsel. Justice Thomas, Justice Alito. Anything further? Justice Gorsuch?
On the administrative review process, your
Yes.
friends on the other side say it would be futile because it's controlled by the state. Thoughts?
The state gives a full de novo review to a disqualification decision. That's clear on their website. It's clear in the administrative rules that govern that proceeding.
Yeah,
they
but
have
they
counsel.
also report to the governor, right?
They do, but let's say you get a bad decision there. You've got an appeal right to the state courts, and you've got an appeal right to this court. So it's a remedy that is fulsome and allows them to make any argument they want.
You emphasize Gonzaga and Tlefsky, but we have other cases too. Wilder, Wright, Blessing. Thoughts about our jurisprudence in this area?
I do. Obviously, Gonzaga and Armstrong have cast a lot of shade on decisions like Wilder, Wright, and Blessing, and I noted that in the Tlefsky decision, this court did not use any of those cases to reach its conclusion in that case. But the problem is that the lower courts are still in a state of confusion about what the status of those cases are. So, for example, in Tlefsky, I believe Mr. Chief Justice asked a question to counsel or observed, haven't we put a stake in Wilder? Well, outside the walls of this courtroom, lower courts have not gotten that message yet. Otherwise, Judge Wilder in his concurrence would not have said, well, we're still bound by Wilder and Wright and Blessing until this court says that those are actually dead cases that we should no longer follow. The problem with a case like Wilder is that the standard it applies is so low. Wilder says the inquiry turns on whether the provision was intended to benefit the putative plaintiff. Well, that kind of sounds like the test that Justice Kagan is propounding this morning, where you don't need rights-creating language. But if that's the case, there is no high bar, there is no atypical case, then the federal spending clause statutes are replete with private rights that can be enforced in federal court.
Justice Kagan?
I think you gave me the option.
Policy, and if the federal government wins 99 of the cases, it won't matter as long as one plaintiff wins and gets a universal injunction. The government has to run the table. These policy consequences are partly about the universal injunction and partly about how it interacts with heightened judicial polarization and extreme forum shopping. That's a point on which I agree with my friend, Professor Vladeck. He is right to criticize extreme forum shopping. He's right that challenges to the Biden administration in single-judge divisions were an egregious problem. Where I think he's wrong is to suggest that it would somehow be rash for Congress, at long last, to address the severe policy problems caused by universal injunctions. If I may, this is the fourth time that I've testified about these problems over the last 7 years. There's also a constitutional dimension. A final judgment binds the parties, and a court order must be followed. No one is above the law. But judgments and orders have this kind of authority in our legal system because of the principle that courts act as courts, deciding a case for the parties and giving remedies to the parties. Once a federal court decides a case and gives a remedy to the parties and the people they represent, there is nothing left for it to do as a court. There is no constitutional authority for the judge to go on and decide the cases of other people or to give remedies to other people not before the court. The universal injunction is emphatically not a partisan problem. Universal injunctions and vacatur are stopping almost every major initiative of the second Trump administration, just like all the Democratic and Republican administrations in the last 10 years. They are a bipartisan scourge. At any particular moment, of course, there is a partisan valence to solving the problem of the universal injunction. But that partisan valence will not last. There are no permanent majorities. In the long term, the real loser from the universal injunction is our democracy. The Republican or Democratic bias oscillates over time. What does not change is the universal injunction's built-in bias against any effective government action. A legislative solution should be laser-focused on non-parties. It should apply to temporary restraining orders and to vacatur under the Administrative Procedure Act. It shouldn't just put guardrails on universal injunctions. Only one proposed bill fits these principles, and that's the chairman's bill. This bill would take the universal injunction and bury it 6 feet under. No evasions, no circumventions, no substitutes, no outs for Republicans, no outs for Democrats. The federal courts are and should be a bulwark against unconstitutional or illegal actions taken by other government actors. They should hold the president accountable, regardless of whether the president is a Republican or a Democrat. But the federal court should perform that essential function as courts do, by deciding particular cases brought by particular parties with remedies that control the relationship between these parties. The last 10 years have seen a fundamental transformation of the relationship between the judicial branch and the executive and legislative branches. It is past time to reset that relationship.
Thank you, Mr. Chairman. Thank you for the invitation to testify before the committee. In my testimony, I'd like to make 3 points about how we got here and then offer some thoughts on the way forward. First, as Ranking Member Durbin suggested, any discussion about nationwide injunctions has to be put into the broader context of the unprecedented moment in which we find ourselves. Substantively, we have a president running roughshod over existing legal constraints to a degree we've simply never seen before. And procedurally, we have a Justice Department engaged in highly partisan and ethically dubious behavior in lower courts that we've never seen from lawyers working for the federal government. Even this committee seems to be of the view that the central problem in these cases is the relief federal judges are imposing, not the lawlessness they're imposing it against. At the risk of bringing data to a mud fight, the reality is not that a small handful of hand-picked judges appointed by Democratic presidents are using nationwide injunctions to thwart the executive branch. As of last Friday, the 46 cases in which district judges have blocked Trump policies have involved rulings by 39 different judges appointed by 5 different presidents of both parties, sitting in 11 different district courts across 7 circuits. That includes 9 cases before district judges appointed by Republican presidents, too. Many of those rulings have included nationwide relief, but not all of them. Against that backdrop, it seems to me that this committee should be especially careful not to react to underinformed calls from the president and his supporters, and rather to be focused on preserving the relationship between judicial independence and judicial accountability, rather than taking steps that might undermine it. Second, it's worth underscoring that federal courts have, in fact, long and routinely issued relief that benefits non-parties and or has nationwide effect. My friend, Professor Bray, already referred to vertical stare decisis alongside Justices Kavanaugh and Barrett. Even Justice Gorsuch, the most visible critic of nationwide injunctions on the Supreme Court, has voted in favor of them at least 11 times since 2020. More than that, any time a court invalidates a state or federal law on its face, rather than as applied to the specific plaintiffs, it is necessarily providing relief to non-parties, since the law can no longer be enforced against anyone. That's not only well settled, there's no serious argument that it's beyond the federal court's powers. And even nationwide injunctions have virtues that other forms of relief do not. Consider the birthright citizenship cases. Do we really think that parents should have to challenge that policy one child at a time? Would it make any sense at all, even on a broader scale, for the scope of birthright citizenship to differ in Arizona, New Mexico, and Texas simply because those 3 states fall into 3 different circuits? Of course, a nationwide class action could solve that problem, but it does not strike me as a coincidence that the rise in nationwide injunctions came shortly on the heels of the Supreme Court's evisceration of nationwide class certification. Chairman Grassley's bill alludes to class actions as a preferable vehicle. I could certainly endorse that idea, but tellingly it does nothing to make them more broadly available, even though Congress unquestionably could do so. Third, it seems to me deeply myopic to talk about the rise of nationwide injunctions without talking about shifts in behavior that have dramatically increased the impact of such rulings, several of which were already referred to by Professor Bray. Don't take my word for it, though. In the last 3 Supreme Court terms, we've seen 5 rulings from the justices reversing nationwide injunctions issued by hand-picked judges in Texas and Louisiana and affirmed by the Fifth Circuit because the plaintiffs in all 5 cases lacked Article III standing. There's no question that nationwide injunctions have been abused, but the abuses in those cases were not about the scope of the relief the courts were issuing. It's only exacerbated by it. And critically, those abuses would not go away even if nationwide injunctions were narrowed or eliminated. Meanwhile, the cost of eliminating nationwide injunctions would be less of an ability to restrain executive branch lawlessness at a moment in American history in which that power has proven singularly vital. So what is to be done? First, if the members' real concern is that the president should have the authorities that courts are denying to him, it seems to me that they could consider legislation to provide those authorities, rather than legislation that would prevent courts from fully and effectively enforcing existing legal constraints. Second, insofar as this committee wants to focus on procedural reforms, it should focus on reducing the ability of individual parties to manipulate the judicial system, not on limiting the ability of courts to hold the executive branch accountable, especially in an age in which Congress has proven less able to do so itself. Finally, if the committee's true goal is to improve the functioning of the judicial system writ large and not just to maximize short-term partisan political advantage, now that Republicans in the White House, the committee could follow the model of other recent court reform legislation and have any reforms go into effect on or after January 20th, 2029. Otherwise, the message this committee would be sending is that its goal is to insulate an unprecedented degree of lawless behavior by the executive branch from meaningful judicial review, a message I can't imagine this committee wants to send, and one that the separation of powers, to say nothing of the rule of law itself, simply can't afford. Thank you again for the invitation to testify. I look forward to your questions.
Chairman Grassley, Ranking Member Durbin, and members of the committee, thank you for the opportunity to testify today. I note at the outset that the views expressed in my testimony are entirely my own and not those of my law firm or any of its clients or any entity with which I am affiliated. Today, the committee considers a recurrent problem in our federal judiciary. The propriety of non-party relief is a question at the heart of our constitutional republic. It is a question that asks whether our federal courts exist to decide cases or to advance causes. It is a question about a practice that renders every judge a king and every court supreme. The statistics show the issue is not confined to one president, one party, or a particular substantive policy. Accordingly, the Department of Justice, across administrations, has consistently argued against granting relief beyond the parties to a case. Just a few months ago, President Biden's Solicitor General explained that, quote, universal remedies are inconsistent with longstanding limits on equitable relief and the power of Article III courts and impose a severe toll on the federal court system, end quote. And jurists on both sides of the ideological divide have recognized the problem. As Justice Kagan stated in a 2022 speech, quote, it just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process, end quote. Before I highlight the many problems with non-party relief, let me offer one concrete example. In 2017, the Department of Justice imposed new conditions on law enforcement grants, requiring participating local jurisdictions to cooperate with federal law enforcement to remove illegal aliens who had committed serious crimes. The city of Chicago sued, alleging the grant conditions were unlawful. The district court issued a preliminary injunction, but rather than stopping at providing this complete relief to the party before it, the court enjoined the grant conditions nationwide. Cases were pending in other districts, and Chicago could not make any claim that its own interests were required nationwide relief. Yet the district judge, with one line of dubious reasoning, exerted power over every other grantee in the country, including those who didn't want it and supported the conditions, and exerted power and precluded any other judge from effectuating a contrary conclusion. The Second Circuit Court of Appeals in New York would later find these conditions lawful, highlighting how incredible it was for a lone district judge in Chicago to dictate the result in New York and everywhere else. With that example in mind, let's just highlight a few of the problems with non-party relief. The first problem with non-party injunctions is, as Justice Thomas has explained, they are legally and historically dubious. The Constitution grants to federal courts the power to hear cases and controversies, which the Supreme Court has long interpreted as the power to render a judgment or decree upon the rights of litigant parties, not non-parties. Some argue that nationwide non-party relief is a necessary check on the ever-growing power of the executive branch. But the answer is not to fix one constitutional distortion by creating another. Rather, if the concern is with the power of the administrative state, then the answer is for Congress to reassert its atrophied policymaking muscle, not to transform the judiciary into a third political branch. The second problem with non-party injunctions is they undermine the norms, rules, and structures that undergird our multi-court, multi-jurisdiction, multi-tiered legal system. One such legal norm is the concept of percolation. There are several legal provisions and practices that reflect this preference for percolation, but I'll highlight just one, and it's the U.S. Constitution. It establishes one and only one Supreme Court and such inferior courts as Congress may establish. In this hierarchical system, one district court does not bind another and one circuit court does not bind another. It is only Supreme Court judgments that are binding on all federal courts. Yet nationwide non-party relief effectively has any of 1,000 district judges wielding the same supremacy as the Supreme Court by stripping from other courts the efficacy of their judgments. The nationwide non-party injunction thus simultaneously makes every court supreme and every court a potential nullity. The third problem with non-party injunctions is they are undermining public confidence in federal courts. History has shown the American people have a stubborn tendency to demand a say in the rules that govern their lives. Humility, then, is a necessary judicial virtue for life-tenured judges who have a share of the ruling power for life and cannot face elections by the people like the other branches. But in recent years, the third branch has lost all sense of itself. It will either rediscover judicial humility or lose the support of the people and force a national constitutional crisis. Because the Supreme Court appears unwilling or unable to rein in its own branch, it is time for Congress to act. 3 legislative fixes seem advisable. First, Congress should amend the necessary statutes to make clear that federal courts do not have the power to grant relief to non-parties. Second, it appears the latest trend in relief is for district courts to enter temporary restraining orders. Those should be made immediately appealable. And third, and finally, even if Congress enacts the above fixes, it is likely that judges who believe they have nationwide power will shift from granting non-party injunctions to certifying classes. Congress should consider imposing mandatory jurisdiction on the Supreme Court for any injunction or similar order that the Attorney General certifies as a national emergency. Thank you. I look forward to taking questions.
Thank you very much. We'll have 5-minute rounds for questions. I'm going to start with Professor Bray. One criticism has been leveled against the legislative solution that I've proposed. It's been that it undermines the judicial branch's checks and balances on the executive branch. Do you think this is a fair criticism, and how would you respond?
Thank you, Chairman Grassley. I don't think it's a fair criticism. I understand where it's coming from because the place of the courts as a check and balance on the executive branch and the legislative branch is very important in our constitutional system. But the way courts do that is by deciding according to the law in particular cases. And then that ripples out to other cases through precedent. That's the way they serve as a check, without fear or favor, following the law in the case. But they serve as a check, as courts do, by deciding cases, by giving remedies to the parties in the case.
Mr. Panuccio, you have direct experience in the Justice Department dealing with non-party relief ordered by district judges. From your perspective, how significant is the problem of universal injunctions to the relationship between the executive and judicial branch?
Thank you, Chairman. It's a great question. I think it's a very significant problem, and I think it is years of this practice are eroding the relationship between the Department of Justice and the executive branch and the courts, and I think that's happening across administrations. What effectively happens when a nationwide injunction is entered is that every single case, every single policy of the executive branch becomes an emergency that needs to move up the appellate ladder very quickly. And Supreme Court justices appointed by presidents of both parties have noted that the increase in the emergency docket is straining the court, it is straining its resources, and it is also reducing the quality of decision making. And so you are seeing increased friction. And even in these district courts that issue nationwide injunctions, I think you're seeing very unfortunate comments made by some of the judges. There is a real tension between the jurists and the lawyers, and it is undermining the typical relationship between the department and the courts.
Professor Bray, you touched on this a little bit in your opening comments. As administrations come and go, the problem of universal injunctions often appear partisan. You've been calling attention to this problem since the Obama administration and have maintained a consistent position across 4 administrations now. From your perspective, is the problem of universal injunctions a partisan one, and then what's the solution?
Thank you, Chairman Grassley. I do not believe it is a partisan problem, because it is a problem that has been hamstringing every administration since 2015. The end of the Obama administration, the first Trump administration, the Biden administration, and now the second Trump administration. So if you look at it over time, it's not a partisan problem. At any particular moment, undeniably, it is a partisan problem and has a partisan valence. But legislation should not just be about the moment. Legislation should be about the long view. And I think the only fair way to do this is to knock out the weapon of the universal injunction for everyone. Take it away from Democrats, take it away from Republicans, because what it really strikes at is our ability to have democratic self-government and effective government action by the federal government.
Mr. Panuccio, in your written testimony, you said that it's important to pass legislation to make temporary restraining orders against the government appealable. The legislation I propose does that. Can you expand a bit more on your views here? What are temporary restraining orders, and why is it important that they be, that they're appealable?
Thank you, Chairman. It's an important question because the latest trend in non-party relief appears to be courts entering what's called a temporary restraining order instead of a preliminary injunction. Now, in my experience as a litigator and in my years as a lawyer, a TRO was supposed to be a very short-term order from the court when it is impossible for the court to hold a hearing with both parties, and it might enter, for example, a 24-hour TRO until it can get a hearing on a preliminary injunction, an actual hearing with adversaries arguing the facts and the law to the court. But what we're now seeing is the courts are entering these TROs, which can, under the rules, last for up to 2 weeks and then be extended for another 2 weeks. And the issue is that the courts have interpreted TROs to not be appealable. Now, that may be a dubious interpretation, but that is the law of the land right now. And so it is effectively allowing district judges to insulate themselves from review. So it's bad enough that we have district judges saying, I am a ruler for the entire nation. But now they're saying, they're not elected, so the people can't have a say. They're also saying that the appellate judges who are supposed to oversee my decisions, I don't want them hearing it either. So let me enter a TRO instead of a preliminary injunction or some other immediately appealable order. So I do think it is virtue of your bill, Chairman, that TROs or any other similar order would be immediately appealable.
Yeah. Senator Durbin, I've asked Senator Moody to take over for me while I go to another meeting. So
she's very strict. Yeah.
You proceed. Yeah. Thank you, Senator Moody.
Thank you, Mr. Chairman. So, Professor Bray, I'm going to ask you to stick with me for a second here and talk about possibilities. Along comes President Trump and decides that the following sentence doesn't make sense. 14th Amendment, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So the president decides one of his 103 executive orders will eliminate that language, the language of the Constitution, and question whether or not birthright citizenship is legal in America. Cases were filed. One judge, a Ronald Reagan appointee, said the efforts by the administration are blatantly unconstitutional. If you accept the normal process which you described to us, how should that case be handled if we've done away with the universal application of decisions?
Thank you, Ranking Member Durbin. I think that's an excellent example of how the courts are supposed to work. The courts are going to decide the cases. In every single one, the courts will say there's birthright citizenship under the Constitution. There will not actually even be a disagreement between the circuit courts, and there won't even need to be a decision from the Supreme Court. So what you'll see is distributed decision-making across the federal judiciary that will resolve the question.
But assume the alternative, that there is a federal judge in some state, I'll pick one, Texas or Louisiana, who says, I think the president's right. I believe birthright citizenship is unconstitutional. So you have a case in controversy, and it affects only the cases filed in that district?
Well, it wouldn't affect just the cases filed in the district, because a district court judge actually has no precedential authority, even within a district. There's no ability for a district judge to.
Well, let me amend my comment. Circuit.
Yes, if a district judge took that position, and then it was affirmed by the Court of Appeals, then what you would have is a circuit split between different circuits, and the Supreme Court would resolve that circuit split. And then what the Supreme Court would have is a range of different judges from different geographical places with different ideologies, different generations, all speaking to the same question. And that puts the Supreme Court in a position to do its best work. I don't think that particular legal question needs to be in doubt, but just because one branch goes beyond its constitutional bounds doesn't mean the judiciary should go beyond its.
So I guess my question is, in light of individuals personally affected by this, pregnant women as an example, we just have to let the process play out? Is that what you suggest?
There are ways to get a faster decision. As Professor Vladeck noted, you could have a national class action. But I think the basic commitment, I recognize there can be a human cost there, but the basic commitment of our legal system is you don't get an immediate right decision right away. It takes time. It's like the old carpentry adage, measure twice, cut once. And that's the kind of legal system we have.
Professor Vladeck?
I mean, I think it's worth underscoring the human consequences that my friend just kind of brushed right past, because if it takes 3 years for that circuit split to get to the Supreme Court, you're going to have 3 years where in large parts of the country, children born to undocumented parents will not be citizens. Some of those children could be subject to removal by the United States on the ground that they are not citizens. It is not possible for the federal courts to order those folks to be brought back. And so that relief that Professor Bray holds out as possible 3 years later is of no help to the children who were citizens under the Constitution, but who were removed in the interim. And so again, I mean, the broader policy question here is what should the rule be in this interim window? Professor Bray and I agree that it's all about what is the status quo while the case gets to the Supreme Court. Should the status quo be the policy is either in effect or not in effect on a nationwide basis, or should the status quo depend upon which jurisdiction you live in and what your particular status is? And that's why it seems to me if we want to talk about real reform, we should be talking about reforms to bolster the other vehicles, the nationwide class action, and not just taking off this stopgap that has emerged in its place.
Thank you.
Thank you, Ranking Member. Senator Blackburn?
Thank you, Madam Chairman, and thank you all for being here. I've got to tell you, being in Tennessee over the weekend and then doing a telephone town hall with several thousand Tennesseans last night, the overreach of the judiciary is something that continued to come up. The way we have seen these activist judges troubles people, and they're wanting to see something done. So they were pleased that we were having this hearing, and they're concerned that you are seeing district judges come in and exercise this sweeping injunctive relief that doesn't apply to the case before them, doesn't apply to the district in which they are seated. So, Professor Bray, I want to talk with you for just a moment. One of the things that Senator Grassley noted and that many of us have discussed is that there is no constitutional and no statutory authority for federal district judges to issue these injunctions. And so talk for a minute about the effect of that lack of authority.
I'm happy to, Senator. So I think that is correct. There is no statutory basis for granting universal injunctions, and there is no constitutional basis for doing so either. So courts, to be courts, have to exercise the judicial power. And the judicial power is not defined by the Constitution, but the Constitution instead uses what's a known commodity, that is the reference to the judicial power. It is courts deciding cases for the parties. So a universal injunction is fundamentally different from that. A class action is still a case. It's a case, it's a large case, but it's still a case, and if the class wins, the class wins. If the class loses, the class loses, but it's a decision for a case. And what makes the universal injunction different is you have a very small case and a remedy that's for everyone. So my friend Professor Vladeck noted this question about like what's going to be the interim rule. Is the interim rule going to be you have a policy or you don't have a policy? And when we have courts disagreeing about what the interim rule should be, we shouldn't default to, as long as there's one court that doesn't like it, it's stopped. That's what makes it a sclerotic effect on government action. The government can't act if all it takes is one court not wanting the rule or the policy to go into effect for the entire country.
Let me ask you also about injunction bonds, because under Rule 65, then a party who is seeking an injunction is required. The bond is mandatory, but we have not seen that used in these nationwide injunctions against President Trump. So speak a little bit about the utilization of injunction bonds and when that's appropriate.
I'm happy to, Senator. I have an above median interest in injunction bonds, and I'm happy to talk about them. So there was an op-ed in the Wall Street Journal a couple days ago that suggested it was a problem for injunctions that were being given against the Trump administration, that no injunction bonds were required. Now, I do think the federal rules of civil procedure require injunction bonds. I think it would be a good practice for federal courts to be requiring injunction bonds. Follow the rule. Require injunction bonds whenever you give an injunction against the federal government. And I think it's a way of taking into account the regulatory interests of the federal government and the costs injunctions impose. That being said, there's nothing invalid about an injunction just because it's not accompanied by an injunction bond. It still has to be followed. That doesn't mean the court lacks jurisdiction. It's still an order of a court, and it must be followed for that reason.
Thank you. Professor Vladeck, I wanted to talk to you about something you said in your testimony, and I thought it was really very interesting. You said that, and I'm quoting, "We have a Justice Department engaged in highly partisan and ethically dubious behavior," end quote. And I could not disagree with you more in that statement, and I really find it just rich with irony after we've sat here for 4 years and watched President Biden's DOJ weaponized against the American people. We had parents that went to school boards that were called domestic terrorists, and we have seen 2 tiers of justice. So you can submit for me in writing, since my time has expired, your explanation of why the Biden DOJ was not highly partisan, and you have assumed that the Trump DOJ is.
Can I briefly
Thank
respond,
you, Senator
Madam
Black. You
Chairwoman?
can submit that in writing. Thank you, Senator Blackburn. And we'll turn it over to Senator Padilla.
Thank you, Madam Chair. Professor Vladek, good to see you. Just wanted to take a moment to follow up on something that you discussed in your opening testimony. Now, there's members of the committee, primarily on the other side of the aisle, that are trying to claim that there's a few radical judicial activists standing in the way of President Trump's agenda. But just as in his first term, it seems that the president's disregard for the law is actually the biggest thing standing in the way of his agenda. So I want to walk through some of the statistics again with you. How many cases have you identified where plaintiffs are seeking an injunction or a temporary restraining order against the current administration where the judge has actually issued a decision, and in how many was the relief granted?
Sure. So, Senator, as of last Friday, and the data obviously has changed since last Friday, the total number of cases we found was 67, and there were 46 of those 67 in which the judge had issued either a temporary restraining order or a preliminary injunction or both.
Okay, that's a lot, and it sounds like a pretty good success rate in terms of the challenges. Now, how many judges have heard these cases? And if you're able to tell or even have a ballpark, these judges were appointed by a president of which party?
Sure. So it's 39 different judges appointed by 5 presidents of both parties, including 2 Republican presidents, President Reagan, President Bush. And the cases are not symmetrically distributed, but the success rate's pretty close. So of those 46 rulings against the Trump administration policies, 9 have come from Republican-appointed judges. And the success rate in those cases has been about 45–50%, so just a little bit lower than what we're seeing in the cases with Democratic-appointed judges.
Okay, that's encouraging to demonstrate that it's not a partisan lens with which these judges are acting. Now, when it comes to geography, can you speak to where these judges sit? Are they concentrated in one region, one appellate court jurisdiction, one district, or are they spread around the country?
It's been spread much further around the country than what we saw, for example, during the Biden administration. So we've seen 11 different district courts in the 46 cases that have blocked Trump policies, 11 different district courts in 7 different circuits, which is a pretty big shift from as recently as a couple years ago when most of the nationwide injunctions against Biden policies were coming from district courts in Texas, Louisiana, and Missouri.
So thank you, and appreciate your verification of some of the data that I have in front of me. To me, it confirms not just the numbers, but that it's not the judges getting in the way of the Trump agenda. It's certainly not a few radical judicial activists either. Now, question on a different topic for you. You're an expert on sensible ways to reform the judiciary to make it better work for the American people in a way that was intended by the framers of our Constitution. In your view, what are the most pressing reform needs when it comes to the federal courts?
Yeah, I think the most pressing needs, are to avoid the more general ability of parties to manipulate the federal courts in ways that we've seen, to some degree in administrations of both parties, but for various structural reasons, I think even more so during the last 2 Democratic administrations. Just to take one example, my friend Professor Bray, joins me in criticizing so-called single-judge divisions and judge shopping. That was a phenomenon we saw over and over again during the Biden administration. The only really sort of obvious target for that kind of behavior during the Trump administration, the district court in Massachusetts, changed its rules actually to prevent that kind of behavior. And it seems like that can be a model, Senator, for a nationwide rule that this body could impose to avoid the appearance that litigants are steering cases to a particular judge because of that judge's ideological commitments.
Yeah. No, and that's critical for the functioning of the judiciary and people's confidence in the process. Last question, in my time remaining, is sadly very timely because the attacks on the judiciary isn't limited to attacks on judges by the Trump administration. Now we're seeing attacks on the legal community and specific firms or lawyers that represent clients and causes at odds with the president's ambition. Can you speak to the chilling effect that these targeted executive orders are having on the legal community and their ability and willingness to take on clients or employees that might dare to disagree with President Trump?
Yeah, I mean, I think we're seeing a chilling effect, Senator, in some of the law firms that are, making these agreements with the president to not represent particular clients, to devote hundreds of millions of dollars to pro bono litigation in support of the president's agenda. That kind of distortion is a problem not because of Democrats versus Republicans. That kind of distortion is a problem because, as the Supreme Court itself explained in 2001, meaningful access to lawyers is actually central to the ability of the courts to play their essential role in our constitutional system.
Thank you, Mr. Vladeck. We appreciate your testimony. Thank you, Senator Padilla.
Thank you. Just following up on that, I mean, is there agreement among the three of you that dealing with forum shopping would be beneficial for the judiciary and for the strength of the rule of law? Do all of you agree on that?
Yes, but it would only solve part of the problem.
Oh, I understand that, but it would be worthwhile. Professor Vladeck, you said that. How about you, Mr.?
Excuse me. I think plaintiffs, if they have the ability to file a lawsuit in a district, should be able to do that. I think the incentive for forum shopping is that you think you can get a judge who can be a ruler for the whole nation. So fix the problem of judges overreaching their power, and you'll.
So you're okay with forum shopping, just so I understand.
Well, it depends what you mean by that, Senator.
I mean,
if you mean
pick where you file, and what lawyer wouldn't do that? Where you think you can win?
Well, there's all kinds of reasons why lawyers choose to file in different districts. It could be because
okay,
of the
I think I got your answer.
But judges,
2 against to reform that, and 1 thinks it's fine. The next thing, just this practical question of a class action lawsuit versus an individual suing. I mean, I'll ask you, Professor Bray, because you're talking about class actions, and I support class actions. There's been a lot of debate within the committee about whether they're useful or not, and a lot of pushback on the use of class actions. But there's an enormously increased burden on the plaintiffs in order to get class certification, is there not?
Senator, with respect, this bill, the chairman's bill, would leave class
I'm not
actions.
asking about the chairman's bill. I'm just talking, I'm a lawyer. Somebody comes in. Birthright citizen is the claim. I'm a small town lawyer. That's what I was, White River Junction. I say, you know what, you're right. Let's take the case. I'll do it. But if I have to go get a class certified, just tell me the steps I have to go through for getting that class certification, as opposed to just taking my client who came into my White River Junction office, and we go to the federal district court in Burlington.
So class certification does require more steps, but it's entirely appropriate given that what you're seeking is a remedy to represent everyone.
No, I'm talking, I understand that it's appropriate. I'm just talking about what is the practical burden in terms of cost, in terms of what kind of legal power you have to have, as opposed to a single lawyer who has a single client who comes in to see me and wants relief. What's it going to cost for me to do a certification for class, as opposed to me just filing and paying the filing fee at the federal district court?
So I do agree, Senator, that there are more requirements, and that means more attorney hours and more costs.
Right.
So I agree with that. But it is also matches the scope of the relief sought. And so it really is a matter of
I get that, but there's an acknowledgement here that it's a much bigger deal. You know, one of the wonderful things about our justice system is that an individual who is harmed can come into a lawyer, and that lawyer may take it pro bono. But if you have to have the resources of a major firm, it's a much bigger uphill challenge to get your day in court. Second thing, you know, we've got a situation here with the courts that's unprecedented, and we've got a real debate on both sides of the aisle about who is weaponizing the court. I understand that. But do you, Professor Vladeck, have a view about whether the and by the way, let me just give a context. The context that we're in right now is the separation of powers in 3 co-equal branches of government. And my view is that the legislature is essentially ceding authority to the executive, and that that's very dangerous in the long run for the well-being of our democracy. That's my point of view. I'm not asking you whether you agree or don't. But I'll ask you, Professor Bray, what do you see as the impact on the rule of law when the executive orders the Justice Department to dismiss a corruption case against the mayor of New York City in order to get his cooperation on a executive policy on immigration?
The rule of law applies to all three branches, and each one needs to act consistently with the law. That includes the executive, and also for the subject of the hearing today, that includes the courts. I am with you in thinking that it is an imperative for every branch.
I know that, but I'm talking something that real world. This happened. We got a major corruption case against the mayor of New York City, and it was dismissed for political reasons. Does that conform to your view of how the rule of law should operate?
No, it does not.
Thank you very much.
Thank you, Senator Welch.
Thank you, Madam Chair.
You know, I was struck by the questions on the law firms and the approach of President Trump to try and bring them back to the table of working with this administration. I was struck, I found some of that ironic and the questioning, Mr. Panuccio, and welcome, great Floridian from the great free state of Florida. Considering the way the law firms approached any conservative lawyer that was coming out of the last administration and the treatment of such, I thought it was very ironic. Did you notice that many lawyers who had stood up for good policies were refused employment or shut out of some of these large law firms?
Thank you, Senator. You know, I'll be circumspect in my answer here just because I'm here to testify on universal injunctions. However, you know, I think it's an open secret in Washington that if you work for a Republican administration, you face a much harder job market coming out than if you work for a Democratic administration. I don't think anyone doubts that to be the case generally over the years, not just specific to the Trump administration, but going back to the Bush administration and others. And you often now hear people say, well, if you take that job, you may never work again. I think that happens much more often with Republicans than Democrats. And it reflects that, you know, law firms, like many institutions in this country, are overwhelmingly weighted in one direction politically than the other.
Mr. Panuccio, you have long been an academic, so to speak, on many of these challenges we see with nationwide injunctions, and I appreciated your testimony specifically when you quoted Justice Kagan, appointed by a Democratic president, when she said, it just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process. And what struck me by that is this term normal process by someone who would know how long it takes to go through the normal process. And that basically means, it could mean the 4 years that an entire term that a president is in office. Isn't that right?
A full appellate process to the Supreme Court could take several years, yes. But, Senator, I would say, you know, to coin a phrase, this is what democracy looks like. The founders at the Philadelphia Convention considered turning the judiciary into what was called a council of revision, which would mean the judiciary had a chance to review laws and policies of the legislative or executive branch before they went into effect. And the founders decided against that. And they said the judicial power is cases and controversies among the parties. The whole point of democracy,
Let me just stop you right there. I want to focus on the normal process, the years it would take to go through the normal process, meaning let's take for a moment that we can rightfully change the law to make sure that the decisions apply to the parties before the court only. For the administration of justice to have any effect and the people to believe that chaos and controversy and conflict can get rightfully addressed expeditiously, should it take years for these cases to go through the courts, or should Congress consider an expedited process for matters of great national concern?
I think it would be appropriate, Senator, for if the Attorney General were to certify a case as of great national importance, for there to be a faster process or mandatory jurisdiction of the Supreme Court. I will say this, though. For individual parties, if an individual party is aggrieved by executive action, or legislative action. The individual party can go to a district court and get an injunction that gives complete relief to that party, and that doesn't take years. That can take days. It can take hours in certain cases. That's why the district courts are there. They're there to grant relief. Now, if what you're seeking is a change in policy nationwide, that is governing. That is what the elected branches do. But for individual parties, I don't think it's years for relief, as we've seen.
And Professor Bray, thank you for joining us. As a former judge myself, as someone who has great reverence for an independent and fair judiciary, it concerns me that the public in general, based on what we're seeing in the numbers, and I thought it was really interesting when we say 46 injunctions or orders that have gone against this administration, 9 were by Republican judges. Do you believe that limiting the relief sought to the parties in front of the court will help alleviate this idea that these are judges acting in a partisan nature?
Thanks, Senator. I do think it will reduce the appearance of partisanship because you get decision-making by more judges across the country instead of one judge giving an injunction to decide the question for the whole country.
So you believe the proposed legislation from Chairman Grassley would address bipartisan concerns?
Absolutely.
Senator Hirono?
Thank you, Madam Chair. This is a question for Professor Vladek. Professor Bray noted in his testimony the concern about extreme foreign shopping, especially in single judge districts. So I think you're familiar with a bill that I had introduced, which I intend to introduce once again, about the Stop Judge Shopping Act. It was not motivated by a concern about nationwide injunctions, but here we are. I think it has relevance. And I'm wondering, Professor, do you think that parties would seek and receive fewer nationwide injunctions if they were not able to judge or foreign shop for favorable outcomes? That's happened in the Texas mifepristone case.
I think there's no question, Senator. I mean, I think the data, such as it is, shows that there was a higher success rate when parties sought nationwide relief during the Biden administration in single judge divisions than when they filed in courts that had random assignment to more than 3 judges. And so, that's a small data set, and I don't want to overstate it. But yes, I think, there's almost no conceivable way in which it wouldn't be smaller.
So that would be, in my view, it would be a fair, I suppose, way of addressing the concern over nationwide injunctions.
So, I would say, if I might, 2 things. The first is that I think distributing assignments would at least mitigate the allure of nationwide injunctions in cases in which the median judge might not issue it. I mean, Professor Bray referred before in the birthright citizenship case to his confidence that any judge would block this order. The issue is not those cases. The issue is cases where the identity of the judge might be dispositive. So that's piece one.
Especially in single judge districts. This is again for you, and perhaps Professor Bray. I'm trying to understand the practical effect of Chair Grassley's proposed legislation, wherein where you limit the relief that a court can grant to only the parties before the court. So I would like to know how, in a case like the mifepristone decision, how the relief granted would apply only to the parties before the court.
So, can I think it's even more powerfully illustrated, Senator, in the birthright citizenship cases, because in a context in which you had, say, individual non-citizen parents, or even, a group of non-citizen plaintiffs, say, in Northern California, seeking to block the birthright citizenship policy, an injunction that only ran to them would be of no benefit to non-citizen parents in Southern California, in Oregon, or anywhere else in the country. And so you would need litigation, on a retail nationwide basis to ensure that that these parents could have confidence that when their children are born in the United States, they're born citizens.
So you're saying that multiple lawsuits must be filed to obtain the relief if we're going to go with what is in Senator Grassley's bill, that the relief will only be granted to the parties before it. There are certain issues that certain cases where it wouldn't make sense.
Well, and so Senator,
To limit it
unless,
that
right,
way.
unless, and this goes back to the chairman's opening statement, unless you were in the same bill to reinvigorate nationwide class actions, unless you were to effectively trade nationwide injunctions for a reinvigorated nationwide class action where you'd be able to show that all non-citizen parents who are, who have a childbearing age, right, are affected by this order.
Professor Bray, do you want to
I would love
weigh
to.
in?
Yes, I would love to. Thank you, Senator. So I think the mifepristone case is a great example. You couldn't really have an injunction to protect the plaintiff's interests there because the plaintiffs didn't have standing. But what the case shows is...
Well, let's say that the plaintiffs did have standing.
What the case shows is the lack of fit in so many of these cases with universal injunctions between tenuous, narrow standing claims, including DAPA, the original 2015 one, the tenuous, narrow standing claims, and massive universal relief.
Okay,
and that's not the way
I'm saying that, let's say that the standing issue was overcome, and then you have a court that says what the FDA did not comport with the APA, and can that court limit that holding just to the plaintiffs before him or her?
Well, in that sort of case, the court should adjust its remedy to whatever the injury is. So you'd have to have a real specific injury to then tailor the injunction to it. And in a case where you don't have one, you can't really have an injunction tailored to the remedy. Tailored to the injury. So we'd have to hypothesize an injury and then hypothesize an injunction that matched it.
Thank you,
I realize my
Professor
time
Bray.
is up, but my point is that I think there are some concerns about the approach that the chairman is taking in his bill.
Thank you, Senator Hirono. Senator Hawley.
Thank you very much, Madam Chair. Thanks to all of the witnesses for being here. Let's just start by talking about the need to be here today and the fact that what we are seeing happen in district courts is, historically speaking, really unprecedented until recent years and completely out of sync with our constitutional system. You alluded to this, Mr. Panuccio, the way that our founders designed our constitutional system. Mr. Bray, Professor Bray, let me just start with you. According to your scholarship, when's the first time that a district court issued a universal non-party injunction of the kind that we're talking about today?
I think the first one is 1963. There is historical debate about when they started in the 20th century, but I think that would be the first one. But they certainly are not traditional in equity before then, and they were a peripheral backwater until 2015.
So 1963, so the Republic is 200 years old almost by the time we get the first district court issuing a universal injunction binding parties who were not before it. And even then, as you just alluded to, then there's this period of quiet where they're really not issued until the 21st century, until the 20-teens. Is that correct?
That's correct.
And then we see this explosion, as you can see in the chart behind me. In the Bush years, Bush 43, we have 6 universal injunctions binding non-parties. In the Obama years, we have 12. You referenced one of those cases, Professor Bray, in your opening statement, your written statement. And then under Trump in his first administration, 64 universal injunctions binding non-parties, 14 under Biden, and now 15 under the second Trump administration in 1 month alone. Mr. Panuccio, let me just come to you. Tell us why this pattern that we're seeing here, and there's a clear partisan valence to it, but there's even more of a recency valence. This is something that just did not happen until very, very recently. Why is this so distortive to our federal system?
Well, thank you, Senator. It's distortive because it has judges operating outside their constitutional role. They are exerting policy-making power over the whole country. And the issue is this. We are a republic. Those who get to exercise policy-making power, like yourself, like this body, have to face the electorate every 6 years, 2 years, 4 years, whatever it is. Judges do not. We gave them life tenure so that they could be insulated and make decisions without fear or favor. But we limited the judicial power to cases and controversies, just the party before them. And in my written testimony, I note that Hamilton said it's the least dangerous branch, but he had a caveat. Only if they exercise the judicial power. If they range beyond it, then it can be the most dangerous branch. And the public's confidence will be undermined because they have no chance to get rid of these judges because they have life tenure. They don't want to be ruled by kings. They want to be ruled in a republic where they have a vote.
And here's my concern is that this pattern of, I think, abuse, this pattern of out-of-control behavior that we're seeing that's illustrated on the graph that's behind me is not decelerating, it's accelerating. And now we're seeing it not just with injunctive relief, we're seeing it in other orders, other procedural forms that are deliberately designed to insulate the judges, the district courts, from appellate review. Temporary restraining orders. You mentioned this, Mr. Panuccio. All of a sudden, we've seen a huge uptick in just the last few weeks in district courts issuing what looks a heck of a lot like a nationwide non-party injunction, but it's styled as a temporary restraining order. Now, Mr. Panuccio, if I were a judge who wanted to insulate myself from review, why might I choose the temporary restraining order vehicle to do it? Why is this happening?
Because, Senator, under current precedent, TROs, temporary restraining orders, are not immediately reviewable, unlike a preliminary injunction. So if you are a judge who believes a policy is unlawful and you want to exert power nationwide and you don't want anyone to review, the voters certainly won't. The only people who can do it are appellate judges. So you issue a TRO, then you extend it for another 2 weeks, and for at least a month, you can't be touched by the appellate courts.
And has this happened in the last few weeks?
It has been happening. We've seen straying beyond the typical preliminary injunction to TROs in other what are being called administrative stays, which also appear to be unreviewable.
So here, I think, is the issue that's before us. In one sense, it's entirely appropriate that we're here today, and it's entirely predictable given the urgency of this situation. In another sense, it's sort of a wonder we need to have a hearing on this at all, because my Democrat colleagues for the last few years have been decrying the very behavior that we're talking about now. And I think, as you pointed out, Mr. Panuccio, we've had multiple members of the last administration. For example, Joe Biden's Solicitor General Elizabeth Prelogar, she herself said in court, by the way, this wasn't a stray comment to the press, this is her at the Supreme Court, a court of equity may grant relief only to the parties before it. District courts violate this principle by issuing universal injunctions. Elena Kagan, Justice Kagan, it can't be right that one district court judge stop a nationwide policy in its tracks and leave it stopped for years while it goes through what is otherwise the normal process. I would just say to my Democrat colleagues, it shouldn't be, to quote the chairman, that one thing, or to quote the ranking member, that it's one rule for Democrats, it's one rule for Republicans. Let's make it one rule across the board that no matter who appoints you, a judge can only bind parties who are before her or him. There are no nationwide non-party injunctions. Let's make that the standard, and let's return these courts to the proper functioning of our constitutional system.
Thank you, Senator Hawley.
I almost...
You stuck to that time. I am so
for
proud
me,
of
it was
you.
really good.
Senator Schiff.
Thank you. I want to take a moment to acknowledge what took place today in the Southern District of New York when the Justice Department dismissed a corruption case against the mayor of New York City, not because of a lack of evidence, not because of any misconduct by the prosecutors in the case, but because of the most serious misconduct of the Attorney General and the top leadership of the Justice Department. Because the Justice Department wanted to leverage that case against the mayor by dismissing the case without prejudice so that they could use him as a political pawn to help effectuate their immigration policy. That just happened today. It is one of any number of serious abuses of the rule of law by this Justice Department. And instead of having a single hearing on what the department is doing, or a single hearing on all the other plainly unlawful acts of this administration, no, instead of having a hearing on any of those things, Republicans are having a hearing on the one tool that can be used to try to mitigate the harm of these illegal actions. Now, I completely concur that whether nationwide injunctions are a good thing or a bad thing has depended entirely on who they're being used against. I count no less than 26 of my Republican colleagues who were vigorously supportive of a nationwide injunction against the use of mifepristone. No problem supporting a nationwide injunction in that case. And of course, on the Democratic side of the aisle, we are applauding injunctions against the unlawful actions of this administration. Where I think I come down at this moment in time gets to your point, Professor Vladeck, and that is the use of nationwide injunctions against an administration that has proven so breathtaking in its lawlessness and who is engaged in such a surge of illegal actions, the effort to do away with this singularly vital tool, I think you called it, at this time would be disastrous for the country. It doesn't mean there is not going to come a time when we should agree on a bipartisan basis to place limits on this capability. I think we should, in particular on the abuse of forum shopping, on picking judges solely on the basis of their political predilection or who appointed them for the purpose of a nationwide injunction. But this is not the moment to do it. This is the moment, frankly, we should be focusing on the illegality, not on the tool to constrain it. That doesn't mean we're powerless to work on legislation on this, and I think many of us have concurred with the idea of legislation that takes effect after this term, when we don't know who the next president is. Senator Cruz, you and I went to the same law school. There was a wonderful professor at the college named John Rawls who wrote a book you probably read about the veil of ignorance, where you cast a veil of ignorance over society, and society would develop rules to govern that society, not knowing their attributes, their race, their religion, their gender, none of that. Well, far be it for me to advocate a further veil of ignorance over this body. We are ignorant enough. But perhaps the ignorance of not knowing who the next president is useful here. We should come up with a sensible reform of injunctions and forum shopping, but there's no way this is going to have bipartisan support unless we defer its application until after this administration, when we don't know which way it will cut. I think the same is probably true about filling judicial vacancies. We have just come to this broken place where probably the only way to get things done of this significance is to postpone their application until we don't know who the president will be. My time is almost up, but Professor Vladeck, in the moments I have left, I would yield to you for any kind of response.
Well, just that, I mean, Senator, I think it's revealing that, you know, I, as the minority witness today, am not here defending in all contexts universal injunctions. I've written before that I think that there are too many of them. I've written before that they raise at least some of the prudential concerns that Professor Bray has raised. And I just want to endorse your suggestion that holistic reform to make litigation against the government less manipulable is something we should all be able to support, but that holistic reform has to be about more than just closing off this one avenue today, when there have been other developments that have closed off the other avenues historically that have made Senator Hawley's examples become so much more relevant today.
Thank you, Mr. Vladeck. Senator Schmidt.
Thank you, Madam Chair. It occurs to me that, and I don't want to retread some of the same tire tracks here, but broadly speaking, really what we're talking about is a separation of powers issue. I mean, this is ultimately, when you distill it, this is one way it plays out. As one of the witnesses had remarked, the founders never envisioned this sort of scenario. They certainly never envisioned the scenario. And the abuse that we're seeing here recently sort of puts an exclamation point on it. But I want to use one example of, and it's not a nationwide injunction, but just take Judge Boasberg's ruling here in our nation's capital. When I think the Supreme Court was very clear in Justice Jackson's famous concurrence in Youngstown Steel that the high watermark of presidential power is when you have congressional authorization, when you're actually performing Article II duties as Commander-in-Chief. And the Alien Enemies Act clearly grants that. It's silent. The text of the statute silent on judicial review, and of course this is pre-Marbury, so they certainly would have never intended that anyway. Yet we've got a judge, and there's other issues at play, habeas, you've got due process that's sort of at play, but you have a judge that feels compelled to make this sort of decision, and inherently it's Article II power and or a political question that's not justiciable. I mean, you could go through a number of different questions. Could the court, a few of them here, could a judge have stopped Andrew Jackson from firing on the British at the Battle of New Orleans because we'd already signed the treaty again? Of course, the answer to that is no. Could a judge stop FDR from responding to the Japanese bombing of Pearl Harbor because they hadn't formally declared war until 2 hours later? These are questions, these are core Article 2 powers. So when we talk about the separation of powers, I think we don't teach civics anymore, but if we did, you would learn that the Article 3 branch, its power is not unlimited either. It's in fact limited. And Congress gets to limit Article 3 power, which is sort of, I think, one of the reasons we're here today. And I think we've seen, Senator Hawley had the graph of when we've seen this acceleration. And I think the chairman's bill, I'm a co-sponsor of it, I think the time is now. And maybe there is this sort of mutually assured destruction that Senator Schiff is talking about. Maybe these are the conditions by which you actually can get something like this done. But I do want to raise one other question. And Mr. Panaccio, I offer this to you. I mean, it's an open secret. The appellate bar and the politically sensitive litigators know that this randomly assigning district court judge thing, something's wrong here. Something's happening. It is statistically impossible for Judge Bossberg to get the cases he's getting. It's statistically impossible. When I was Attorney General in Missouri, we saw this in the 8th Circuit. The one Democrat-appointed judge ended up on the panels. It's statistically impossible for that to have happened in that period of time. So I wanted to ask you, what are some reforms that we might consider to ensure that this is truly random? Because if one of the remedies is that you actually have a randomly selected district court judge, then they ought to be a randomly selected district court judge. Do we have like a lottery? Do we have a big wheel? What are some ideas? Because I think there's enough suspicion right now that it's affecting the credibility of the court.
Thank you, Senator. I'm not an expert on the wheels across the country. My general understanding as a litigator is that most courts employ a wheel. How that wheel is weighted can change from district to district depending on the judges. So, for example, in one of my home courts, the Northern District of Florida, there is a public order that tells you exactly how the wheel will work. 35% of the civil cases to this judge, 60% to this judge, 5% to that judge. My own view is that the more transparency courts have, the better, so that at least the public can know this is how the wheel is working. Even if you don't see the wheel operate, you at least know this is the weighting of the wheel, and that can be based on how many active judges you have, how many senior judges you have, how many judges you have in the district, and the geography of the district.
Well, I would just suggest that I think that in addition to what we're talking about here today, there probably ought to be more reforms contemplated, because this, I think, you don't need to be some soothsayer or the oracle at Delphi to understand that there's something amiss here. Thank you.
Thank you, Senator Schmidt. Senator Whitehouse.
Thanks very much. Thanks you all for being here. The first thing I'd like to do is put into the record a partial list that my office pulled together of nationwide injunctions against the Biden administration that my Republican colleagues celebrated and rejoiced in. So this is a bit of a what side are you on, who's in power right now type of debate we're having. The second thing that I'd like to do is to point out that the discomfort to fury, that's kind of the general range, about decisions against the Trump administration may actually have a lot to do with the unprecedented lawlessness and law-breaking of the Trump administration rather than a weird cabal of judges trying to intrude. And it rolls into something that's very important to the court right now, which is threats to judges and to their families, which I think there's significant evidence to show has been orchestrated and is systematized. It obviously starts at the top with people like Trump and Musk making threats about impeachment and whipping up. In the case of Musk, he has curated a whole armada of characters to put it nicely, on X, who, when he targets an individual, barrage that individual with abuse and threats. The idea that Musk does not know that he has this curated armada of, let's just say, not entirely all there individuals who are willing to go and harass and threaten when he's identified a target. Seems unlikely, seems like he knows, seems like it's deliberate. And in that regard, I'd like to put into the record a letter that I wrote to Judge Bredar, who is the new head of the Judicial Security and Independence Task Force. For the first time, the judiciary's felt it has to put together a task force to deal with the campaign of threats that begins at the top with Trump and Musk and then works its way down to where individual judges are not only critiqued, that's fair game, but they're threatened. They're threatened with impeachment to the point where the Chief Justice has had to stand up and say, no, no, no. If you disagree with the decision, that's an appealable issue, not an impeachable issue. So I ask that both be put into the record, both my letter regarding what they have to do. Here's my concern.
Without objection.
I don't know that the Marshal Service is actually going to provide the protection that the judges need. We had a very good response to the Rhode Island judge who was subject to these threats. The court is very impressed and pleased with what the Marshal Service did in that instance. But it gets a little bit different when you start going after, it seems always to be female family members. When you start going after spouses, wives and daughters and things like that, you know, if you go after a judge's daughter who lives in a different location, how does the Marshal Service respond to safety issues related to the daughter who lives in a different city, who's not even in the district for the marshals? What do you do about that? And do the marshals have any authority to do any investigative work to see what can be done to understand the threat posture that these judges are facing and who's behind it, and when is it deliberate, or are they constrained only to provide protection but not look into what the threat is? I think those are really important questions, and I hope that this judicial group will take a good hard look at that, and that's what my letter requests. The last thing I'd suggest is, this ain't that easy. If you are a district judge and you decide that a rule is unconstitutional or an action is unconstitutional, and that action plays out across multiple states, that, as the law of that case and as the law on that subject, ought to be applicable in other districts. And the idea that every time some action is deemed unconstitutional, you've got to file it 93 times to hit every single district before it can apply. I mean, I think we get into some very significant practicality issues as we mount this little crusade that runs exactly counter to where my Republican colleagues were when the shoe was on the other foot.
Thank you, Senator Whitehouse. Senator Cruz.
It's long been said that hypocrisy is the tribute that vice pays to virtue. I have to admit, I'm enjoying listening to my Democrat colleagues suddenly discover the virtues of the rule of law after 4 years where they brazenly supported the most lawless Department of Justice and the most politically weaponized Department of Justice our nation has ever seen. We just heard the senator from Rhode Island talk about the imperative of protecting judges. And yet not a single Democrat senator cared about the violent protesters that showed up outside Supreme Court justices' homes, including, I might note, female justices like Justice Amy Coney Barrett, threatening their family, and Joe Biden's attorney general didn't do a damn thing and refused to enforce the law to protect those judges. Why? Because he agreed with the violent protesters and he wanted to intimidate and threaten those judges. Professor Bray, under our Constitution, who should decide elections, the voters or unelected judges?
The voters are the ones who should vote in the election according to the the laws, and the laws sometimes have to be applied by the judges if there are cases.
And under our Constitution, who is charged with making policy decisions? Elected representatives elected by the people or unelected federal judges?
I think the question of policy, Senator, is a little broader than the particular case. So the laws should be enacted by Congress. That's where the fountain of law.
Policy decisions of the elected branches.
Right.
Law is the province of the court. Policy is the province of the elected branches. These are not complicated. Professor Bray, let me ask you this. Do the federal courts have power to issue remedies for people who are not parties to a case?
That's a question I agree is not complicated. They do not have that power.
Is the phrase nationwide injunction or universal injunction found anywhere in the Constitution?
It is not.
First chart. In the first 150 years of our republic, how many nationwide injunctions were issued?
My view is that there were not any until 1963.
0. Now fast forward. How many nationwide injunctions were issued in the entire 20th century?
It's a small number. I would think it would be a dozen, give or take. It's not large.
27, actually. Excluding Trump's first term, how many nationwide injunctions were issued in the last 20 years?
Far more than that.
32. From 2001 to 2024 against Biden, Obama, and Bush, 32. And how many nationwide injunctions have been issued in the last 2 months alone?
There have been quite a few.
37. Let that sink in. There have been more nationwide injunctions in the past 2 months against President Trump than in the entire 20th century. There have been more nationwide injunctions against President Trump in the last 2 months than both terms of George W. Bush, both terms of Barack Obama, and Joe Biden's term. We saw during the Biden presidency lawfare, indicting President Trump 4 times, using the machinery of justice to attack him, and that was an attack on democracy, because Democrats today hate democracy. Democrats today are angry at the voters for re-electing Donald Trump and electing a Republican Senate and a Republican House, and they engaged in lawfare to stop democracy from operating. Understand, this is the second phase of lawfare. Second chart. This is the second phase of lawfare. Now that their efforts to indict President Trump and stop the voters from re-electing him have failed, they're going and seeking out individual radical judges to try to shut down policies, and they are forum shopping like crazy. Give me any loon judge put on the bench by Obama or Biden who disagrees with a policy. We just saw a judge flagrantly ignore U.S. immigration law concerning TPS being revoked. U.S. law explicitly said there's no judicial review for that, but hey, they found a judge who says, you know what? We, the Democrat Party, we are the party of illegal aliens. We are the party of murderers and rapists and gang members, and the Democrat Party exists here to fight to keep murderers and rapists and gang members in your communities. There's a reason the Democrat Party is at 26% approval nationwide, because they put radical policies ahead of rule of law. Nationwide injunctions are an abuse of power. It is the judiciary acting as policy deciders, and it is incumbent on this committee and this body to rein in the abuse of power from these unelected radical judges who are trying to overturn the election because they disagree with what the voters decided.
Thank you, Senator Cruz. Senator Klobuchar.
Okay, that was a lot. Let me start with a few things. Number one, we love the democracy, and I believe what we should be having is a civil debate about how we can best, if Donald Trump wants to make changes to the government, we should be doing it in a legal way, not how he's doing it. And the only reason there's all these injunctions, Senator Cruz, is because he's violating the Constitution. Why would Trump-appointed judges...
Why don't you file them in red districts?
Senator Cruz.
Why What did you just say?
Why don't you file them in red
Cruz,
districts?
point
Why
of
are the
order.
Democrat attorneys
Senator Cruz.
general seeking out
Senator Cruz,
left-wing
my
blue
esteemed
single
colleague.
Quite patient with
One
Senator
second.
Cruz's activities
Yeah.
in this building.
Senator
I think
Whitehouse.
He's entitled to.
I'm just going to ask for a point of order. Madam Klobuchar, Senator Klobuchar.
Senator Moody, we have debates on this committee. They occur regularly.
Let's let her have her time, and then we'll get back to that. If you want to wait, we'll get back to you, Senator Cruz.
She's welcome to
Senator
answer the
Klobuchar,
question or
go
not.
ahead.
It's their choice.
Go ahead.
I'm so
and I would
excited
encourage
to
you
be
to answer.
following Senator Cruz once again.
Excuse me?
But I will say
Excuse
this.
me? I didn't hear you. What did you say?
To be following him. He and I have a long
I was permitting you your time to continue. To be following him in order.
And I
Excuse
have
me.
a
Go ahead, Senator
long-standing
Klobuchar.
debate during hearing.
Go ahead,
That's
Senator
what I'm
Klobuchar.
referring to.
Go ahead.
And I will take more than my time, since he's taken more than his time to yell at me.
Go
So
ahead.
what I
I'll
will
mark the
say
time.
is that
I'm not yelling. I asked a question.
Senator Cruz, please, I'll give you time. Senator Klobuchar, I've got the time, and you'll be allotted
I
the time.
am making the strong case that the reason all these cases have been filed and the reason that these judges who have been appointed by Ronald Reagan, yes, they still exist, and the Bushes and Donald Trump, judges appointed by Donald Trump, have been making these decisions is because this is not legal. Donald Trump himself has used his social media account, the White House account, to post an image of himself wearing a crown saying, "Long live the king." The issue is that we do not live in a kingdom, and Elon Musk is not his court jester. Ours is a nation of laws in which no one is above the law. That is why 39 different judges from vastly different backgrounds, appointed by 5 different presidents, have made clear that these are illegal actions. And these judges have rightly blocked these actions. And it is important that we not lose sight of the underlying cause of these injunctions. It is not that these judges are crooked or lunatics or evil. Those are words used by the president and his allies. It is because the administration is violating the Constitution. What happens when they use these kinds of words? You see more and more threats against judges. And that is what we're seeing. That is why federal judges and the U.S. Marshals, who are responsible for protecting them, are sounding the alarm about a spike in threats against judges. This is serious. And unlike what Senator Cruz said, I'm remembering when the threat was made, the horrific threats, and the man was in Justice Kavanaugh's, on his neighborhood, on his street. On a bipartisan basis, we came together and got more funding for the judges and changed things so that they had more protection. So what he said was completely untrue in terms of Democrats and Republicans decrying violence. We didn't just decry the violence, we actually did something about it in response to a court that is run by Justice Roberts, who is a Republican appointee. So I think that kind of language actually makes the situation worse when it's not even true. But unfortunately, Senator Cruz left, so he did not hear my response to what was a lie. President Trump's attacks on these judges has made for some major, major risks for these judges. I would ask you, Mr. Panuccio, and not in a partisan way, just normal, as a partner in a law firm, have you ever taken to social media to personally attack a judge who ruled against you? That's all my question is.
Senator, thanks for the question. I think that attacking judges personally and not their reasoning, well, let me just give you a quote. I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind and you will pay the price.
I've asked
you. Want to know, you won't know what hit you if you go forward with those awful decisions. That was something that Senator Schumer said, and I thought it was awful, and it unleashed a wave of violent threats against Supreme Court justices. I do think that's problematic, that kind of language.
I have no doubt the language is a problem on the left or right. I was just asking you if you have ever personally attacked a judge after you disagreed with the ruling. I'm asking you.
I have not.
You did it. Thank you. And you believe that the proper recourse is to appeal when you disagree with the ruling?
When I disagree with a ruling on behalf of a client, I appeal.
Thank you. That was all I wanted. I was not going to criticize you. I believed that you would not have done this. And so that is my point. When people do this, and right now we have not just a random person on social media doing it, We have the President of the United States doing it. And I would just ask you, Professor Vladeck, in your opinion, are the judges who ruled against the president radical and rogue judges?
No, and just if I might, even though he has also left the room, Senator Schmidt suggested it was statistically impossible that Chief Judge Boasberg has been assigned to multiple cases in the D.C. District Court. I think that rhetoric is highly inflammatory, in addition to being just mathematically incorrect. There are 31 different cases in the D.C. District Court alone in which D.C. district judges have ruled against the administration. There are 11 or 12 active district judges. The notion that one of those judges would have multiple of those cases is not statistically impossible, it's statistically certain.
And if the president does not want to have judge rule against him, isn't the answer that he just follows the law?
One would think, but I think we live in a bit of an upside-down world at the moment.
Okay, so this hearing was titled in a very academic fashion, Universal Injunctions. And we can make it all academic if we want. Clearly we haven't with Senator Cruz's remarks. But I just want to make the point that this has a real consequence, that these cases that are coming before these judges. This is outside of their decision, which is based on the law and the facts. Sometimes they've ruled with the president, sometimes they've ruled against the president. But just to get it so people understand this isn't just some academic exercise about injunctions and if they're a good thing to have legally. Last month, a federal judge blocked the administration's plan to slash NIH funding for medical research. Could you talk about the impact if the judge had not been able to issue a nationwide injunction?
Sure. So Senator, briefly, because I know our time is limited, NIH hands out thousands and thousands and thousands of grants. If you required the recipients of each grant to litigate the rescission of each of those grants on a retail basis, you would have gaps in cancer research. You'd have gaps in all kinds of work by the National Institutes of Health, because it's not possible that those thousands of the mass action by the government could be challenged on a retail basis in federal courts.
Thank you so much. And
could I get a second round
Senator
of questions?
I allowed you to go way over your time in order to make up, and I wrote it down.
Round?
No, ma'am. I just wanted to let you know that I did give you extra time and over what was taken up.
Okay,
so thank you so much. Okay. I appreciate it.
Okay, a lot of times when senators are still here and there is no one else here, they let them have a second round?
Absolutely. I'd just like one moment to ask about an issue that came
well,
up
yes.
that is regarding TROs. And I just want to make sure that the committee as a whole has an understanding of TROs, how they are used, so that they can take this into account in the proposed legislation. TROs have been used historically by judges, and they haven't been immediately appealable. And it is in the proposed legislation that we change that practice through law and make sure that TROs are appealable. Do you think that would remedy some of what is happening today and some of the distrust that certain judges are making partisan rulings? Mr. Panuccio.
Thank you, Senator Moody. I do think that when a TRO, well, let me step back. TROs now are starting to look a lot like preliminary injunctions, and preliminary injunctions are immediately appealable. And so it really shouldn't matter what label the court puts on it, whether they call it an administrative stay, a TRO, or a preliminary injunction. If the court is enjoining preliminarily, before a party has proven, before a jury or a judge, entitlement to relief, if they're getting that injunction, it should be immediately appealable, no matter what the label is.
And that would make a significant change in court procedure in comparison to how it's been applied historically.
It would. There is some very recent scholarship out about how exactly it came to be that TROs are not appealable. But given what's happening, yes, legislation to address it would probably be the most expeditious way.
So that seeks to expedite review of some of these cases where judges are issuing nationwide orders. And I want to go back to something that we've heard pretty much on both sides of the aisle today, questions pertaining to executive authority, Article 2 authority, and whether or not that should even be reviewable in some instances, especially as it relates to national security matters. Are there instances to alleviate partisan concerns? And I'm sure as a lawyer, it causes you great concern for the stability of this nation and our separation of powers. that there would be a suspicion of partisan agendas among our judges. That's concerning, correct?
We want our judges to be seen as nonpartisan and applying the rule of law only.
And would there be an instance where utilizing a 3-judge panel might alleviate those concerns?
Thank you, Senator. We have instances of that. There are numerous different kinds of cases where a 3-judge panel, the statutes require that a 3-judge panel is convened, and sometimes it is because the cases are of significant national importance or have some kind of, I don't want to say partisan, but important valence to them in terms of the policy. So we see this in redistricting cases, for example. There are 3-judge panels. So there is a place for 3-judge panels, I think. You know, I will say that I personally don't believe that we should say if someone seeks a nationwide injunction or non-party relief, it goes to a 3-judge panel, because that would give the imprimatur of validity to non-party injunctions, and I don't think they're valid if 1 district judge does it, or 3 or 17. I don't think district courts have that power.
But certainly in some instances that might be indicative that the public may prefer a 3-judge panel for assurance of impartiality, that might be preferable.
Right, or another way to put it is just to make sure that there is greater deliberation among intelligent judicial minds about major issues. So, for example, you could have, in substantive areas, you could say, look, if it's a case about the president's wartime powers, it's not going to go to a single district judge. It's going to go to 3 judges, because we'll get the benefit of 3 times the benefit of judicial reasoning.
And even if there were a 3-judge panel, the need for expeditious review would still be important if it is a matter of great national concern or interest.
I think expeditious appellate review of cases implicating policies of significant national concern is important.
Senator Brett.
Thank you, Madam Chairwoman. Wanted to go ahead and jump in. I know that you've talked about a lot of the issues that I wanted to bring up, but Professor Bray and Mr. Paniccio, I'd like to turn to talking about the Administrative Procedures Act and vacature. And one of the provisions of the Judicial Relief Clarification Act, which I am proud to be a co-sponsor of, amends sections 705 and 706 of the APA to limit relief to the persons before the court. My question to the two of you is, can you discuss the emergence of the APA vacature and in the broader conversation surrounding universal injunctions and the importance of addressing that issue in any legislation that addresses the universal injunction problem that we have before us today?
Gladly, Senator. So the Administrative Procedure Act allows challenges and judicial review of agency action. And there is a vigorous debate among scholars about whether the Administrative Procedure Act should be understood as allowing a separate remedy of vacatur. I don't think there is such a remedy of vacatur. There's no traditional remedy called by that name. You won't find it in remedies casebooks or treatises or anything else. But there's a vigorous debate about that. What I don't think you can really debate is the interaction between vacatur and universal injunctions. So one of the things that we've seen, especially in the Biden administration, is litigants and courts were shifting from universal injunctions to vacatur, especially as appellate courts and some of the concurring opinions from the Supreme Court started to express more skepticism of universal injunctions. And that kind of switch is really important for a legislative solution. It means a legislative solution has to tackle the vacatur problem as well. Otherwise, you're just going to play whack-a-mole, and you're going to stop universal injunctions, and all the same things will be done by courts against agencies, at least, under the APA.
Thank you.
Thank you, Senator. Professor Bray is the expert on the history of this. I will just say that, as he has said, the issue of nationwide injunctions or vacatur is, they're one and the same. At the end of the day, it's the court granting relief to parties not before it. There is the issue of the set-aside language in 706, and I think any legislation that's going to address the issue of non-party relief needs to take that on. To just take on injunctions would then, in most cases, allow courts just to say, well, I'm going to look over here to the APA and do the same thing.
Okay, thank you. Professor Bray, I want to get your response to some of the criticism we've heard for those that are opposed to curtailing repealing universal injunctions. Let's start with the criticism that we shouldn't eliminate universal injunction because it could lead to inconsistency and an inconsistent application of the law around the country, or in some form of, as you have called it, disuniformity. As you've written about, it seems to me that the question is not about whether we have uniformity. It's more a question about at what level our legal system and our court system is such nationwide uniformity actually achieved. And so the process to get there and how we achieve that, I think, is kind of what is at question. What's your view on the question, and what's your response to the disuniformity criticism of limiting universal injunctions? And relatedly, is disuniformity an inherently bad thing?
So I think there's a lot of value to uniformity in the law. The question is how and when and who gets you there. And in our legal system, we get uniformity, but we get uniformity over time. And I think one of the striking things that you see for universal injunctions is they are proceeding on a premise that the first judge selected with highly intense forum shopping and in a time of high judicial polarization, that the first judge who takes the question is going to be right. But often universal injunctions get reversed or narrowed on appeal. And so there should be no presumption of the first judge to tackle the question is the one who should get us to uniformity. Instead, the right way to get to uniformity is through appellate precedent, which, as Justice Kagan said, is the normal process.
Absolutely. Well, thank you so much for your time.
Thank you.
Thank you, Senator Senator Klobuchar.
Yep, just two more questions here of you, Professor Vladeck. Federal judges, we were going through NIH and what that would mean if you had to have an individual case in every single grant in every single jurisdiction of the country, which is why we have this ability on the nationwide front. Let's look at something else. Federal judges blocked the administration's funding freeze that jeopardized everything from community health centers to child care to infrastructure to support for law enforcement. Can you talk about the impact if those judges had not been able to issue a nationwide injunction, including on non-parties?
Sure. I mean, I think we would have seen, Senator, overnight, tons of entities that depend upon those federal funds to provide vital services to everyone, just having to close up shop and not being able to provide those services because they don't have the money. And so, Professor Bray is right that the question is uniformity at what point. I think part of what has not been fully explicated in our conversation this morning is that one of the justifications for uniformity earlier rather than later is irreparable harm. And is the notion that but for this kind of relief at this early juncture, Mr. Panuccio has been attacking TROs for most of this hearing. TROs are based on the idea that the harm the party is facing is so urgent that there's not time for the ordinary process. And I think we really haven't done a lot this morning to talk about how these policies are harming people in ways that create, to me, extraordinary justifications for these kinds of judicial interventions.
Okay, last one. Judges have blocked the administration's plans to empower Elon Musk to rummage through American Social Security information, my words, probably not the words in the law, and get access to their bank accounts, tax returns. This is all the DOJ-related looking at things. If judges had not been able to issue a nationwide injunction, what would be the impact on the American people?
I mean, again, it's different facts, same problem, right? Which is, you'd need retail litigation by, every American whose Social Security information has been compromised, or you would need to somehow overcome the insuperable barriers that the Supreme Court has created for class certification. And so, I don't mean to beat a dead horse, Senator, but it seems to me that those who are averse to nationwide injunctions, but not to the notion that the federal government should be acting within the confines of the law, should actually be supportive of reforms that would strengthen the nationwide class action as a procedurally proper and historically precedented device for restraining the executive when the lawlessness is on such a wide scale.
Thank you.
Thank you.
Thank you, Senator Klobuchar. Ranking member.
I want to ask a question of Mr. Panuccio, and I think you addressed this earlier, and I want to make sure there's clarity, at least in my mind, on your response. President Trump's executive orders attacking a number of law firms because they employed attorneys who were involved in litigation or represented clients that he did not approve of. I also understand that he's withdrawing security clearances for some members of those law firms, which of course would impact their client relationship and their ability to do work. What is the impact of those executive orders on the targeted firms?
Ranking Member Durbin, you would have to ask those law firms what the impact has been.
What message do you think these executive orders send to the legal community more broadly?
I think you'd have to ask the legal community more broadly.
I'm asking you. You're with a law firm, and it's not unreasonable to ask you. Has it come up in conversation in the last 2 weeks among your colleagues?
Well, it's not what I was invited here to testify about,
Well,
Senator. I
still-
think all of these law firms have the ability, if as with any party in this country, to seek individual relief in a court, as many of them are doing.
Yeah. So you kind of think just routine legal work.
Routine, well, challenging an executive order, whether it was in the Biden administration or this administration or the Bush administration, has become routine in this country, and the courts are open for those individuals to seek redress.
Professor Vladeck, do you have any thoughts on this subject?
I mean, I don't mean to repeat myself from before, Senator. I just think that, we should all be invested, and by we, I mean lawyers, law professors, members of Congress. The courts thrive when they are receiving the best possible arguments from the members of the bar. And, I think everyone's going to have their own views on who has weaponized what against whom. I think the notion that we should be getting to a place where the executive branch is openly threatening law firms in contexts in which those threats are designed to prevent lawsuits against the federal government jeopardizes the very accountability that the separation of powers exists to protect.
Professor Bray?
I think you need a strong and independent bar to represent the interests of all the people in the United States.
Thank you.
Thank you, Ranking Member. And because we allowed them additional questioning, Senator Britt, would you like to have any additional questions?
Absolutely. Thank you so much. Mr. Pananucci, as someone who worked at DOJ, what's your response to the argument of the universal injunctions are a good thing to help prevent having to relitigate the same issue in multiple jurisdictions?
Thank you, Senator. That's not how our multi-tiered hierarchical court system works. The whole point, the first ground for the Supreme Court to take jurisdiction over a case, the reason it will grant cert, as they say, number one reason they will say is if there is a circuit split. Well, how can we ever have a circuit split if we have a district court, which is lower than a circuit, issue a rule for the whole country?
Right.
The whole point is we have percolation. We have over 1,000 district judges in this country to apply their judicial reasoning. And Justice Ginsburg, it's in my written testimony, she had a very eloquent explanation of why percolation, why getting different decisions from different judicial minds is important. So it is not within our historical tradition to have one judge set a rule for the whole country and have that uniformity. That's not what our legal foundation is built upon.
Absolutely. Thank you so much. I appreciate it.
Thank you, Senator Britt. I want to thank the witnesses for your time this morning. I know this has been a long morning, but certainly a topic that is important to this entire country. All eyes and attention is on this right now, so we are so grateful. I think what we have learned today is there is a very keen interest to address making sure that our judiciary remains impartial and that it is making rulings only in terms of relief as to the parties before it, and that we are encouraging expeditious resolution of these extraordinarily important matters, especially as you have a president that is trying to deliver on promises made to the American people and restoring safety and justice to this nation. So with that, I thank you for your time. I thank you to everyone that has participated in the hearing today. Certainly, this is the people's house, and it's important that we have members of the public here with us as we are debating and addressing these important issues. Written questions may be submitted for the record until April the 9th at 5 p.m. I know certain senators asked for written responses if you're willing to provide them, and with that, the hearing is adjourned.
I'm joined now by Congressman Daniel Goldman. Thanks so much for taking the time.
Thanks for having me again, Brian.
So within the last few days, there has been this issue that's bubbling up to the surface, and that is this threat by Donald Trump that he will seek to serve a third term. First of all, because I know that this is going to be, I want to get into the legality of this in just a moment, but there's a lot of talk back and forth about whether him even bringing this up is just to serve as a distraction from the even worse things that are happening in his administration right now, from the stock market tanking to the trade wars.
Rand Paul, hardly a Democrat. Tariffs are simply a tax. Senator Mullen, tariffs is a tax. He didn't have the right grammar, but I'll read him verbatim. Tariffs is a tax, and it will be passed on to consumers. According to the New York Times, 6.5 million jobs would be impacted by the Canadian tariffs, and people in red states will be especially impacted, from farmers to small businesses. And here's another problem. It's chaotic. He says one thing one day and another thing the next day. He changes which countries, he changes the percentage, he changes which goods. And what do businesses hate? Uncertainty. Whether you're a small business, a medium-sized business, a large business, you want certainty. There's no certainty. That's why the stock market has gone down so much. Consumers, why is their confidence at lower levels than it's been in a very long time? In part, in good part, because of these tariffs. They say, if I'm going to have to pay more for eggs or for bread or for gas or for a car, I better not spend now. So it's creating huge problems in the whole economy. So soon, the Senate will vote on a resolution from Senator Kaine to undo Trump's tariffs on Canadian goods, and we hope that some of our Republican colleagues will join us in that. They don't like the tariffs either. They know they're a tax hike on the American people. They know that the stock market is in turmoil, risking people's retirements. They know that consumer confidence is down, and the odds of a recession, something people hate. It's harder to find a job, keep a job, maintain your weekly budget if a recession occurs. And now our greatest financial prognosticators are saying the chances of recession because of these tariffs, this tariff tax, goes way up. So we're going to fight these tariffs tooth and nail. Trump's done a lot of bad things. This is way up there. Ask American people. And one final thing. Look at what happened in Wisconsin yesterday. The American people understand that Trump is not on their side on tariffs, on tax cuts for billionaires, on cutting Medicaid, on cutting the others. The American people are seeing how bad Trump is. Tariffs is a good part of it, and they are not supporting people like Elon Musk and those who support Donald Trump. Tim.
Thank you to Leader Schumer for being a great partner in this effort. And here we are. It's an unusual procedure. There are not many things where even one senator can file a motion that will be guaranteed a floor vote. But the crafters of this legislation, the International Emergencies Act, believed that while a president might need to declare an emergency, that should not go unchallenged if members of Congress felt like, hold on a second, let's get this right. No one is denying that there's a fentanyl challenge in the United States, a huge challenge. We've all seen it in all of our states, And that is why this is not an action to undo the Mexico tariffs or undo the China tariffs. You might argue about whether the emergency is one that where tariffs is the right answer, but clearly the fentanyl trade is being heavily driven through Mexico or precursor chemicals from China. But Canadian tariffs are not the answer to the solution, because the fentanyl problem is not primarily a Canadian problem. There's an article that's out in the Globe and Mail today that digs into the disparities. 21,000 pounds of fentanyl seized from Mexico coming across the border last year, and there's a claim that there's 43 pounds seized from Canada, but the article that's just come out from the Globe and Mail suggests it's actually a good bit less even than 43 pounds. Is there work that we should and need to do together on fentanyl? Of course. Chuck led us to pass the Halt Fentanyl bill in the Senate just 2 weeks ago, and there's more we can do. But this is not about fentanyl. It's about tariffs. It's about a national sales tax on American families. Trump's economic advisor, Peter Navarro, said that the total of these tariffs will be $6 trillion of taxes paid by American consumers, more than $600 billion a year. I've told the story of this baker that I have in Virginia. April is her name. She owns a bakery. Some of you might know this place. It's called Mom's Apple Pie. Now, is this a good thing for a speech in the Senate recording studio? Mom's Apple Pie Bakery. April owns it. 3 locations: Loudon, Purcellville, Occoquan. I was with her recently. She said, "Tim, you got to do something about these Canadian tariffs." And I said, April, you got these 3 little bakeries. I mean, Canadian tariffs, how do they affect you? Pie tins. All aluminum pie tins, they all come from Canada. You increase the price of a pie tin by 25%.
And it's even worse if you have a can of beer with your apple pie.
There you go. Or try some whiskey or something. The pie tin goes up by 25%. And she said nobody has to buy an apple pie. It's to celebrate somebody's birthday or a party. And if the price of a tin goes up by 25%, I sell fewer pies. I may have to lay people off. She's been through it in round 1 with Trump's tariffs in the first term. My largest business in Virginia is the shipyard, Huntington Ingalls Shipyard in Newport News. Ships and subs, critical to our nation's security. 35% of the aluminum and steel that are used in U.S. ships and subs comes from Canada. The other 65% is American-made steel. We're having a hard time producing ships and subs on time and on budget now. These tariffs kick in, it's going to get much worse. I'm very, very proud that this is a bipartisan bill. Rand Paul is an original co-sponsor of the bill. He's going to take the floor at 3 o'clock today for a half hour to talk about this. But I'm also proud with the number of stakeholders that have signed on. This morning, the U.S. Chamber of Commerce signed on to support SJ Res 37, the AFL-CIO, the sheet metal workers, the steel workers, the U.S. Conference of Mayors, the National Taxpayers Union. Mike Pence started a think tank after he stopped being vice president. I think it's called American Freedom Alliance. They came out yesterday. Vice President Pence's think tank came out to support SJ Res 37. We have support left, right, and center because people don't want Americans to have to struggle to pay more for groceries, pay more for building supplies, pay more for apple pie, for God's sake. I'm really happy to be joined by Senators Alsobrooke and Senator Welch, and I think Senator Welch might be up next.
He is.
Yeah, thank you very much. You know, nobody supports tariffs economically. Economists have looked at this, and they don't work, and they do a lot of hurt. So what we have with the Trump policy here is essentially a faith-based economic plan. There's no evidence that it works. There's overwhelming evidence that it fails. And the American people are going to get a history lesson starting very soon about Smoot-Hawley, 2 names that don't immediately come to mind. But it was just before the recession that the U.S. had the highest tariffs in our history. And those tariffs were put in place by the president who got it wrong and thought this would help us. Well, it helped us usher in the Great Depression. And since then, presidents on both sides of the aisle have steered clear of these trade war tariffs until President Trump. Now, second, we have an affordability crisis in this country. Working families are struggling to pay their bills. And just in Vermont, to make it very concrete, we get a lot of our electricity from Canada. We get a lot of our gasoline on the northern part of Vermont from Canada. We get our home heating fuel from Canada. And those bills for folks are going to go up immediately. Home heating fuel, gasoline, electricity. Why in the world would we do that? The other thing is that Canada's our friend. It's not China. And along the border, where we have decades and decades of mutual respect, we're starting to change that into distrust. And a confident country treats its allies with respect. And these tariffs are going to do direct and immediate economic harm to everyday Vermont families and farmers, maple sugar producers. But it's also going to start eroding the trust that is the benefit of good relations over time. Why in the world would President Trump want to be Smoot-Hawley? That's what he's embracing. Totally, totally bad, totally wrong, doomed. And the only question is, how much pain will he inflict on everyday Vermonters before he comes to his senses and withdraws this tariff policy? Thank you.
Senator Alsobrooke.
Thank you. I want to thank Leader Schumer and Senators Kaine and Welch for being here today. You know, President Trump has dubbed today Liberation Day. And I continue to think how tone deaf and how arrogant it is because I'm asking myself, for whom? You know, who's liberated? And I think that Elon Musk. Yeah, I think the reality of it is that middle class and hardworking families like the one I grew up in, I regard myself in so many ways as having grown up in a blue-collar family. A father who was a car salesman, a mother who's a receptionist, and the fact of the matter is the people who are being liberated are the billionaires. None of his policies, including these tariffs, anticipate any relief for hardworking and middle-class families. And so those who will be liberated are not us. And furthermore, he went on to say very arrogantly, you know, there's going to be a little pain, some minor pain and disruption, but the people that I represent don't regard increasing cost of groceries, increasing cost of owning a home, increasing cost of owning an automobile as a minor disruption. But it is a minor disruption to billionaires who can certainly not only afford the increasing cost of goods, but who will also enjoy a tax cut on the back end of this. We know that the taxes that we're looking at, the tax cuts will net, we believe, Elon Musk about $50 million in tax cuts over a 10-year period. So the cynical nature of these tariffs is really, really very disturbing. And so I have, my first bill is a Tariff Transparency Act. That has been filed. I'm going to go to the floor today and ask for a unanimous consent on. And if it is in fact the case that these tariffs are a minor disruption and this is Liberation Day, we're simply asking this administration and my colleagues on the other side of the aisle to prove it, to be transparent with the American people, to tell us the cost of these tariffs. And I can tell you, I've met in my state with people from every corner of the state. Just a couple of weeks ago, had the opportunity to sit down with farmers. Some were poultry farmers. I met with business owners, and many of them feel betrayed by this administration. The farmers who said, you know what, now not only the retaliatory tariffs will cost so much money. Some were selling chicken parts to other countries, and they've said to me, you know, this is going to cost us money, and they did not anticipate that they would see actions that harm them as well. And so I want them to prove to us, who does it benefit? That's a question that I think is a fair question. Is when he says a little pain, who does he mean? Who should sustain the pain? And I would say it absolutely should not be the middle class and hardworking families of this country who pay for the tax cuts for his billionaire friends and who suffer beneath these tariffs. And so we say, again, if it's a minor disruption, and this is Liberation Day, we just simply want to know who should be liberated. And I think that the Transparency Act will show us that.
We'll take questions on this subject. This subject. Yes.
Quick question. About 3 weeks ago, you said that as Trump becomes more unpopular, that Republicans will wake up and they will start to break from him. Do you think the fact that Republicans are joining Senator Kane's resolution on this shows that Republicans are waking
Well,
up
look,
to the unpopular?
the number one factor in terms of Trump's unpopularity is the American people. And he is becoming less and less popular, particularly on issues like this, on the economy. His numbers are underwater rather significantly, depending on which poll you do. And once the American people say, I don't want to embrace somebody, I don't want to vote for somebody, I don't want to support somebody who embraces Trump's policies, things begin to change. But public sentiment is everything, and we are letting the public know in every way we can, fighting every day on how bad the Trump policies are for them. Yes, in the back.
Senator Schumer, there are a lot of dairy producers in New York and Vermont, and as you know, dairy producers have faced import restrictions in Canada. Is it fair for Trump to use some leverage here to get Canada to reduce its trade barriers on dairy?
Look, are there certain tariffs that make some sense in a specific area where we're being treated unfairly? Yes. But the kind of meat axe, blunderbuss approach that they use across the board on everything and huge amounts is typical of this administration. They don't think things through. You know, I dealt with Trump on tariffs back in 2017 when he was president because I was a hawk on China and so was he. And I met his people. I met this guy Navarro. The guy had no basis of any facts and he sort of had to leave the administration. Now he's back running the tariff policy. They don't, as Angela talked about, they don't look at the facts. He just gets this idea in his head that it's going to be a good thing and does it. And then he says he doesn't care if the American people pay more. It's crazy.
Chuck, can I say something.
Yes, Tim, please.
Just real quick, what a great question. Because the dairy issues I've heard Chuck talk about them. I've heard Tammy Baldwin talk about them. There's a Trump-created mechanism to deal with that problem. The USMCA, negotiated by President Trump. I think it got 89 votes here, heavily bipartisan. Why are they not using the MCA to deal with it? Because they want money for a tax cut.
Yes.
If they used MCA to negotiate the differences, they wouldn't have Peter Navarro saying, we're going to get $6 trillion that we can use for a tax cut. That's the way they should deal with this problem. A Trump-inspired, state-of-the-art trade deal that gives them a mechanism for resolving disputes. The fact that they're throwing that aside and going with tariffs tells you that there's something else going on.
And in just across-the-board way. You know, now probably when we're treated poorly across the board, like with China, a broader approach might be necessary. When it comes to Canada, when it comes to Mexico, when it comes to Europe, where we have such complicated, intercombined relationships, that kind of approach hurts only one group, the American people, the average American family. On this subject, yes.
Thank you, Leader. What is your response to the President's argument that these tariffs will lead to reshoring of manufacturing overseas and allow for a level playing field for U.S. industries?
Yeah, well, he gets these ideas in his head. He has no proof, and most every study, and these guys know this, has shown that that doesn't happen. Plain and simple. That's the problem. There's no factual basis here. It's a crazy idea in his head that hurts American families and does very little benefit, and in an untargeted way that makes no sense. Yes, in the back there.
The House introduced a resolution to challenge the emergency declaration on Mexico as well. Are there plans to do that in the Senate?
Tim?
One at a time. So I did an emergency challenge on the energy emergency last month, and we're all in on Canada. There are different issues. You know, Canada and Mexico are not completely the same because of some of the issues with respect to fentanyl. So it's different. But let's get this one done. And if we can get this one done and succeed, then we also have to see what President Trump does this afternoon. Exactly. There may be a whole new series of trade or tariff-related motions coming your way soon.
Lord knows. Yes.
Leader Schumer. Yeah, Mr. Leader, as you're saying, the Trump administration says they'll get money from tariffs, they'll use it for tax cuts. This is at the same time as Leader Thune seems to be proposing, as part of reconciliation, a zero baseline for the current tax cuts. The parliamentarian will probably have to rule on that, but do you think that that comports with Senate procedure possibly?
Okay, that's a different problem, but another huge problem he's causing. It wasn't the same, but you're so nice. I'm
Thank you.
The bottom line is this. If they go through current policy baseline, it will increase the deficit on the United States by $30 trillion, virtually doubling it. And who's going to pay the price? Us, our children, our grandchildren. It just makes no sense. It's hocus pocus. What Mr. Chip Roy, looking for the beard, Chip Roy called it fairy dust. It's a scam. It's a scam to allow them to get more tax cuts for the wealthy. And it's going to hurt the rest of us. Thank you, everybody.
Leader Schumer, on Wisconsin, do you think Elon Musk should keep playing in these races?
She's nice too.
Thanks, Becky. Appreciate it.
There are a number that are still thinking that haven't played, so there's a little bit of drama today.
So do you think it'll be higher? There's more. You're saying that. Can we ask? Can we ask?
No, because it's just there's others who haven't declared, and they're reaching out and asking questions. So I don't know. You have to ask people what their own votes are.
Why are there?
At Wayfair, we're game for every style.
Let's play charades. I'll act out my favorite chair. Got it. All right, ready?
Yep.
This is Democracy Watch. Mark, we have watched as Donald Trump
support, staff was able to intervene when the student was confronted with an unexpected situation and misunderstanding concerning their beaded cap being worn at graduation. Title VI staff handles this situation immediately. This student's commencement experience could have gone from being one of the happiest days to the worst days. Acknowledgement of challenges such as suicide, substance abuse, bullying, homelessness, foster care, sexual assault, missing indigenous children, and the struggle to meet basic needs is evident. These challenges are not just statistics we look at, they are the lived experience of many students. These challenges may not always be fully resolved, and outcomes may not always align with what our families hope for, but the Title VI program helps make each situation more manageable. Our staff works directly with families to do what is needed and to help Native families in our schools feel comfortable. Without Title VI, our students are at risk of continuing to be left behind. Supporting the success of thousands of Native students is critical, and direct funding to school districts should continue without interpretation. I thank you for this opportunity to speak before you. Wadiglo.
Thank you. Dr. Worrell, welcome.
Madam Chair, Senator Murkowski, Anshawatki, and honorable members of the Senate Committee on Indian Affairs, may I first thank the committee for holding this critical hearing. My name is Rosita Kahani Worrell. I serve as president of the Sealaska Heritage Institute, which is an affiliate of Sealaska Corporation. Sealaska was created under the Alaska Native Claims Settlement Act of 1971 to settle our Aboriginal land claims. SHI's mission is to perpetuate and enhance Tlingit, Haida, and Tsimshian cultures of Southeast Alaska. We have been fortunate in establishing relationships with Native entities throughout Alaska and with the Native Hawaiians that implement Native educations funded by the Department of Education grants. We have discussed with them the challenges of Indigenous education and the persistent lack of funding. The fiscal crisis that the state of Alaska has been experiencing has translated into minimal funding for Native education, making federal funding even more important. Despite these challenges, we can confidently state that through our culture-based programs that we have integrated into schools with DOE funding, we have witnessed measurable educational achievement among Native students, as well as improvements in their social and emotional well-being. Through our discussions and relationship with Native Hawaiians, we also found that we share similar priorities, programming, and demonstrated benefits from DOE support and funding. We also share a common theme. Culture-based educational program supports educational achievement. I would like to review key elements of Native educational success. These findings are directly interlinked with support and funding from the DOE and demonstrate the importance of that department. Key elements of Native educational attainment. Number one, DOE support and federal funding were key in supporting the direct involvement of Native entities in their children's education and to actively engage with school districts and school boards to promote and develop relevant educational programs for Native students. Native involvement also supported policy and systemic changes in schools that have come to recognize the importance of integrating Native studies. The data we collected and demonstrates academic progress had largely been absent until Native entities began to receive education grants to develop and implement culture-based programming in schools. Number two, DOE's support and federal funding allowed Native entities to develop culture-based programming and to develop curriculum and educational materials that embody and reflect Native cultures, values, and worldview. Number three, DOE support and federal funding supported cultural orientations and instructions for non-Native teachers and Native teachers training in the University of Alaska system. Number four, DOE support and federal funding allowed Native entities to establish partnerships and to infuse funds into financially stressed partner school district and the University of Alaska system to support Native education. Today, SHI has partnerships with 15 school districts, 16 tribes and tribal organizations, 2 educational organizations that facilitate the disbursement of funds and programs throughout our region. Additionally, we have partnerships with the Bristol Bay Foundation and the Arctic Slope Community Foundation, which are also supported by federal educational funding. While we have made significant progress, Native student scores continue to trail behind reported averages for all students, demonstrating that the need persists for continued Native educational funding. The academic success fostered among Native students can largely be attributed to ANAP, the Alaska Native Education Program. ANAP grantees have successfully intervened on behalf of Native students and families to contribute to their success, both academically and socially. However, we are aware that the level of ANAP funding is not sufficient to allow more Native entities to participate in ANAP. Because of its significant impact in Alaska, SHI has recommended an increase in the 2026 ANAP appropriation to $70 million. I would like to conclude with a recognition and thanks to the Department of Education and its staff for their invaluable support, and to Congress for enacting laws and providing funding to support quality education for Natives and students across the country. With adequate funding, students and educators can have access to quality education and tools that reflect their heritage while equipping them with the skills necessary for future success. Gunachish.
Gunachish, Dr. Worrell. Welcome, Ms. Russell.
Chairwoman Murkowski, Vice Chairman Schatz, and distinguished members of the committee. Thank you for the opportunity to testify today. My name is Nicole Russell. I'm the Executive Director of the National Association of Federally Impacted Schools, or NAFIS, representing more than 1,000 federally impacted schools nationwide that educate nearly 8 million students, more than 105,000 on tribal lands. Federally impacted school districts are those which depend on the continued support of Impact Aid, the oldest elementary and secondary education funding program that represents the federal responsibility to reimburse public schools for lost property tax revenue due to non-taxable federal property, such as Indian and restricted fee land, Alaska Native Claims Settlement Act land, and other property. NAFIS is grateful for Congress's bipartisan support and hopes that strong support will continue. 8 committee members have joined the Impact Aid Caucus, and 7 signed a bipartisan Dear Colleague letter led by Senator Lujan supporting robust Impact Aid funding in FY25. Impact Aid is not a handout. It is a federal obligation born of treaties, trust responsibility, and the unique status of tribal lands as non-taxable. Public schools that serve Native American students and all students impacted by federal lands face significant fiscal disadvantages because they cannot rely on traditional property tax revenue to fund their schools. Impact Aid exists to bridge that gap. Today, we are confronted with serious discussions about the potential dismantling of the U.S. Department of Education and the erosion of federal support for public schools. Eliminating the department would be devastating. In fact, well over 90% of Native American students are educated in traditional public schools. Impact Aid is administered efficiently, sending funds directly to school districts, which allows school leaders the flexibility to make local decisions, precisely the kind of governance many are advocating for today. Many schools that receive Impact Aid are the economic engines that drive that community forward. Impact Aid can be used for any legal purpose, including special education services, transportation, culturally relevant instruction, language revitalization programs, or teacher housing. Moving Impact Aid to a different agency would introduce unnecessary bureaucratic hurdles, result in a loss of valuable institutional knowledge, and lead to significant delays in payments. If the department is dismantled, the very schools that heavily rely on Impact Aid will be the first to suffer. Despite its importance, Impact Aid has not been fully funded since 1969, leaving schools struggling to fill those gaps. NAVES is grateful for Senator Lujan and Senator Tillis's leadership of the bipartisan Advancing Toward Impact Aid Full Funding Act last Congress. Many school facilities serving Native students are in urgent need of repair. Unlike most public schools, federally impacted districts have limited to no bonding capacity to fund school construction or renovation. Impact Aid construction grants, funded at only $19 million annually, provide critical funding for infrastructure improvements, yet demand far exceeds available resources. That's why we are grateful to Senator Hirono for leading and Senator Smith for co-sponsoring the Impact Aid Infrastructure Partnership Act, which proposes enough funding for access to safe, modern educational facilities and expands the use of funds to include teacher housing, a major challenge for many Native communities. Impact Aid has tribal consultation requirements, ensuring that schools meaningfully engage with tribal representatives and parents. These policies promote collaboration, transparency, culturally relevant solutions, and equitable access to educational resources. Impact Aid reflects this nation's moral and legal obligation to Native communities. I urge Congress to prioritize and protect Impact Aid, the education of Native American students, the next generation of Native leaders, and the integrity of our nation's promises depend on it. Thank you for your time, your attention, and your continued commitment to tribal lands and federally impacted communities.
Thank you, Ms. Resel. And we turn to Ms. Rose. Welcome.
Chairman Mikowski and members of the committee, thank you for the opportunity to testify today. My name is Anawake Rose. I'm a citizen of Cherokee Nation, and I serve as the president and CEO for the American Indian Higher Education Consortium, also known as AHEC. AHEC's vision is strong sovereign nations through excellence in tribal higher education. We accomplish this by supporting our 34 accredited tribal colleges and universities, or TCUs, which operate more than 90 campuses and sites in 16 states. TCU serves students from over 250 federally recognized tribal nations and embody a vital component of tribal higher education. Rooted in treaties and authorized by the Constitution, the federal government's unique responsibility to tribal nations has been repeatedly reaffirmed. These trust and treaty obligations are owed to tribal nations and their citizens and do not have an expiration date. They are also not bound just to the Department of Interior, but extend across the federal government, and education is a central component to these obligations. The federal government has long endeavored to uphold this duty through the appropriations process and through the enactment of such laws as the Tribally Controlled Colleges and Universities Assistance Act. Tribal nations began chartering their own institutions of higher education in the 1960s for two reasons: the near complete failure of the U.S. higher education system to address the needs of, or frankly even include, American Indians and Alaska Natives, and the need to preserve our culture, our language, our lands, our sovereignty. The guiding vision of the tribal college movement is an education system founded on traditional knowledge and focused on a prosperous future through job creation and strengthening our communities. Today's TCU offers certificates as well as associate's, bachelor's, and master's degree, and Dene College offers our first doctoral degree. TCUs train professionals in high-demand fields, including law enforcement, agriculture, natural resource management, information technology, early childhood education, and healthcare. By teaching the job skills most in demand in our community, TCUs lay a solid foundation for tribal economic growth, with the benefits for surrounding rural communities and the nation as a whole. In addition to the over 25,000 attending tribal colleges this academic year, TCUs serve as community hubs, serving over 100,000 community members annually through various programs and services such as our libraries, job training, high school equivalency programs, Head Start, financial literacy, community gardens, and youth and college prep. To administer these programs, TCUs receive funding from several agencies, including the U.S. Department of Education. Our written testimony goes into detail for most of these programs, but I want to quickly highlight the Title III Strengthening Institutions Program, which is frankly one of the most important resources for tribal colleges. The core funding is vital to the flexibility and meeting the unique needs of our TCUs. They It allows us to purchase and research in scientific equipment, support faculty development, develop and improve academic programs, create and improve facilities for distance learning, and most critically, it allows for the construction and renovation of instructional facilities. For example, at UTTC in Bismarck, North Dakota, Title III dollars support and supplement new construction and rehabilitation projects across their 124-year-old campus. This includes a greenhouse, a cold storage building, and lighting for outside spaces. At Chief Dullknife College in Lame Deer, Montana, Title III dollars fund math and science faculty, cultural staff, and language immersion programs. As Congress begins to consider proposals to restructure the Department of Education and whether tribal-specific programs should be moved to other agencies, AHEC requests that all programs for which TCUs are eligible entities or receive direct set-asides, such as the Title III program, be considered. Any cut in funding, freeze, or delay, or frankly, any TCU-specific funding that is block granted and inefficiently rerouted through state governments would result in drastic cuts to faculty and staff and frankly, threaten our accreditation status. It would also be inappropriate to send funds that are directed to TCUs through the federal trust and treaty obligations to states. AHEC appreciates the Senate Committee on Indian Affairs for hosting this vital hearing, and we remain committed to working collaboratively with the committee as a trusted resource to ensure that TCUs, tribal nations, and their citizens have a voice in shaping their education future. Thank you.
Thank you, Ms. Rose. We have started our second vote, so I am going to, I think what I'll do is I'll turn first to you, Senator Smith, and then I will ask a question, and then I may take off to vote. We'll work this out, but I want to try to keep us going without having to take a break, if that works. So let's begin with you.
Thank you so much, Chair Murkowski. I really appreciate that. We'll work it all out, and many thanks to all of you for being here.
Is your mic on, Tina?
Oh, sorry. Very informative and useful panel, and thank you so much, Chair Murkowski. I'd like to start by focusing in on impact aid. And Ms. Russell, I'll direct my questions to you. I appreciate how you are highlighting how cost-effective and efficient impact aid dollars are. And I also appreciate how the entire panel, in one way or another, started with the unique trust and treaty obligations that the federal government has towards Indian education, that this is not a program that can just be cut by somebody, that it is part of our longstanding obligation, too rarely lived up to. So I think that was a really important place to start. We know, as I said, that impact aid is very cost effective, it's very efficient, and Madam Chair, I'd like permission to enter into the record testimony from the National Indian Impacted Schools Association, which is headquartered in Minnesota, related to this topic. Thank you very much. In this testimony, Brent Gish, who is NIISA's executive director, explains how impact aid is a model for efficiency, as you've just described, and local control, and also how it has never been funded to meet the intention of the program. So, Ms. Russell, what I'd like to ask you to discuss is we have the recent a so-called continuing resolution with funding through the end of this fiscal year. We have the executive actions and their impact on impact aid. I'm hearing that from my local school boards just how difficult it is to try to hold it all together, given what are very serious worries about getting shortchanged. So could you just help people who don't understand this completely, give me some good arguments for why this has such a tangible impact on the ability of schools to do what they need to do?
Absolutely. Thank you for the question. Impact aid is one of the few federal funding programs that is not forward funded, meaning we rely on annual appropriations so that the school districts can receive their funds, which they're still waiting on since passage of the FY 2025 year-long CR. Our federally impacted school districts we're experiencing serious delays in funding and have been because Congress hasn't passed appropriations in recent years, on October 1st. So these school districts have waited almost an entire school year to receive current year funds.
Right.
And we expect a couple weeks, from passage of appropriations for the funds to reach, ed to then be dispersed to the school districts. And once they do reach ed, they can be dispersed very quickly. And those funds go directly from the Department of Education to a school district's bank account. So it's very, quick and direct funding. Our concerns are we already know that the, passage of the CR and the funds have not gotten to these school districts. They are running into serious cash flow problems.
Right.
And not
this
just
is
because.
what I'm hearing as well.
Yeah, not just because of Impact Aid, but
literally can't pay the bills.
Right. One, school district in particular I heard from this week, we're talking 3 pay periods away from needing to borrow funds just to make payroll. So these are very dire circumstances that our school districts are facing. And when they so heavily rely on federal funds, like federally impacted school districts, Impact Aid, and other federal funding programs you've heard about today, these are serious, serious problems.
Yeah.
And we need to make sure that funds are getting to the school districts in as quick a manner as possible.
Right. I think this is something we all need to pay such close attention to. I'm quite concerned about it. Ms. Rose, I want to just take a minute, at the very few minutes that I have left. I am such a huge fan of TCUs, and we have 4 TCUs in Minnesota, and I just had a great opportunity to meet with a graduate of one of them this past week. And I wonder if you could just take the bit of time that I have left to talk about what you are seeing about, these sort of cutbacks at the federal level and the impact on TCUs.
Well, we're so happy to have a fan of our tribal colleges, and thank you, Senator, for all the work that you've done to support us over the years. We're very, very grateful. Our immediate impact that we saw, not only were we on the chopping block right away with the elimination of our executive order, so the loss of the office within the Department of Education was incredibly heartfelt for us, as we lost an ongoing voice that supported our tribal colleges and universities across the Department of Education. But the most immediate impact was frankly with Haskell and SIPI, as they were targeted with the severe loss of staff, 25% or roughly for both of them. We've been able to return those staff, but at great challenges to the school, as the students felt unloved, unappreciated. The faculty felt desperate. A lot of concerns about whether they would be able to maintain their programs or be able to graduate. What you saw was a tribal college community come around and support each other. And so when we say we have a TCU family, that's absolutely what happened.
People mobilized.
Absolutely. We mobilized to ensure that there was faculty present, administrative teams present, and so all there to make sure SIPI and Haskell had all the resources they need. But more largely than that, we're deeply concerned about programs such as Title III. While there is a lot that has been laid out about what the administration would like to see done to some programs and services, there's other pieces within our post-secondary portfolio that we just don't know what the future of is.
Right.
And post-secondary funding right now is not a secure piece. We're also deeply concerned about Pell Grants. 75% of our students rely on Pell Grants, a larger proportion than any other part of the population. And so without consistency in funding, that's going to really impact our students and in turn impact our institutions.
Thank you. I'm out of time, so I want to be respectful of the chair's time, but thank you for that very good summary in a short period of time.
Thank you for that. Dr. Worrell, you have spoken very well about the benefits that we see through ANEP, and the reason why we need to be focused on doing all that we can. The average reading scores in 2022 in Alaska for Native 4th graders and 8th graders, well, not just in Alaska, across the country, 14 to 20 points below average compared to all students. And so recognizing and trying to address these gaps, I think, is important. Over the years, I have been the recipient of the Baby Raven Reads program. I'm still working through my first and second and third editions. I think right now I'm on Eagle, which is chalk. I did okay?
Yes.
All right. See, I'm learning slowly, but I look at what has been done through programs like Baby Raven Reads, where we're working to address phonetic awareness. It's some of the basic things. But when you mentioned that you have 15 different school districts now, many in the southeastern part of the state. I visited the programs there in Juneau, where they have incorporated the native language into these early education programs, where we are benefiting not only the native students, but also the non-native students within these schools. So can you just share with the committee how programs that are funded by ANEP or the Native Hawaiian Education Grant Program too, how where we are addressing that achievement gap between native and non-native students, and then how this is different really than what is already offered within the school district, how this insertion actually makes that difference.
First, I think we have to enroll the senator. I think we have to enroll the senator in the Baby Raven Reads.
I think so.
We have 30 Baby Raven Reads books, and you've been through 3. So
I know.
Yes.
I have the more advanced ones too. I'm working on this one.
Senator, the answer to this, I'll try to make it simple, but it is complex and it's rooted in history. And you have to remember that when schools were first introduced in Alaska in the late 1800s, that the policy was suppression of native cultures. That was the policy. And that continued probably up until the 1960s, when self-determination became a policy of the government. And I think in Alaska, that was also then followed by the Alaska Native Claims Settlement Act, which has a social responsibility also to its constituents. And so they were able to put money into our schools as well. And then we heard this, rally, cultural survival, cultural persistence. And we then began to see measures of improvement in Native education. But it was really when we started to get federal funds for Native education that we saw some real progress in our educational achievement of Native students. And that was largely through a couple of things. Number one, it was the direct engagement of Native people in education. And you have to remember that a lot of our parents were raised in boarding schools, and so they hadn't had the benefit of understanding, learning cultural values and practices about being engaged in their children's education. So that funds allowed that direct participation of Native entities and Native parents. And then we have Baby Raven Reads, where we integrate Native culture, Native integration of cultural programming into educational curriculum, and then integration into the schools. And, you just look at Baby Raven Reads. It's very different from the books that we grew up with, where Jane and Mary, or Mary and Jane. Dick and Jane. Yeah, Dick and Jane. That was the norm. And so Native people, they saw little white kids doing little white things that little white kids do. They didn't see themselves. They didn't see brown kids. They didn't see their lifestyles, picking berries, going fishing, and things like that. So, Baby Raven Reads, I think, is a really good example of Native programming. And I noted that in 2020, the reading scores improved by 20 points. That's significant. And I have to share with you that today, or as of September 2024, in Juneau, Alaska, in Juneau School District, that Native literacy scores are higher than non-Natives.
Wow.
So I have said this is a model that should be integrated into Head Start across the country. The other part of your question talks about when you don't have Native programming, what happens? Well, we still have school districts that have not integrated cultural programming into their schools. And we don't see the kind of academic achievement, that we see with schools that have that. In fact, we have schools like in Juneau where and this is earlier, where there was schools within that school district that did not have Native programming. we had Native programming in one of the schools, and it was called TCLL, Tlingit Culture, Literacy, and Language. And when we did an evaluation of those students at the end of the year, we found that Native students who attended TCLL, their scores were higher than Native students that did not attend TCL but attended other schools in the same district that didn't have Native cultural program. Their scores were lower. So we know clearly from our data, our evaluations, that the integration of language and culture into schools promotes academic higher achievement and higher school retention and better social and emotional well-being.
Well, thank you for that, and congratulations. That is not only market improvement, but that is really breathtaking when you think about how far you have come. I'm going to excuse myself and go vote. I'll turn the gavel over to the vice chairman, and you haven't given your opening statement. Senator Cortez Masto is next up. You get to decide, and whoever's not speaking can actually read from my collection of Baby Raven reads while I'm out.
Thank you, Chair Murkowski. One of the federal government's core trust and treaty responsibilities to American Indians, Native Hawaiians, and Alaska Natives is to provide education. The Department of Education plays a critical role in fulfilling this promise on everything from impact aid and Indian education programs to Native language revitalization. And for over a century, Congress has passed law after law affirming and reaffirming this federal obligation across the Department of Education, including Elementary and Secondary Education Act, IDEA, the Higher Education Act, the McKinney-Vento Act, Johnson-O'Malley Act, Indian Education Act, the Native Hawaiian Education Act, the Tribally Controlled College and University Assistance Act, and the Native American Language Resource Center Act. Each of these laws was enacted to provide critical support for Native students and schools across the country, no matter where they attend BIE schools, tribally controlled schools, public schools, tribal colleges and universities, Alaska Native and Native Hawaiian serving institutions, or Native American serving non-tribal institutions. Not to mention more general education laws that benefit Native children and Native and unhoused Native children, people with disabilities, and federal loan programs that help 87% of Native students attend college. So what does it mean when the president, by executive order, proposes to dismantle the education department, first by gutting its workforce and then by handing control to the states? Let me start by saying this, and this is maybe the most important thing. An executive order is not a law. It is an instruction about how to implement a law. It can be a powerful tool, but it does not supersede a statute, and it certainly does not supersede a series of statutes. Congress passes laws, the president signs and executes, and the duly enacted federal laws that I just mentioned govern Native education. The president does not get to wash his hands of the federal government's trust responsibility by memorandum. If he wants to eliminate that trust responsibility, he has to come back to this committee and to this Congress. So going back to the original question, what does the proposal do? Well, Native students, more than 90% of whom attend public schools, will be at the mercy of state governments that have no trust and treaty responsibility to meet their unique needs. For rural Native students, eliminating the Department of Education would lead to fewer choices and tremendous instability. High poverty and smaller schools, especially those in rural Native communities, are at greater risk of closing if enrollment drops below the minimum. But do not take my word for it. I'd like to enter into the record without objection the accounts of tribal schools that are operating day to day, not knowing how or even if they will stay open amid the chaos that this administration has caused. I am committed to ensuring federal laws implementing the federal promise of an education to American Indians, Native Hawaiians, and Alaska Natives is not broken. We have a duty to fight this reckless plan on a bipartisan basis and protect Native students. And so I thank the witnesses. I apologize for being late. And my first question is pretty simple. And we'll just go down the line, starting with Mr. Dropick. Did any of your organizations ask to dismantle the education department or voucherize its programs? Just a yes or no.
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 No, absolutely no.
No. No.
Thank you very much. Ms. Rose and Ms. Dropick, did the education department consult with the tribes on any of the proposals to date, including dismantling the agency? Ms. Rose first.
They did consult on the EO for vouchering the schools, but they did not consult on the closing of the Department of Education.
And in your view, does that violate the law?
Yes.
Mr. Dropick?
Agreed. Yeah, they did not.
Okay. Ms. Yellowfish, does your Title VI Indian Ed program currently answer to your state?
No, it does not.
Ms. Rose, do TCUs currently have to answer to states on how they spend their federal funds?
No, they do not.
I'll just end with one final comment because between my opening statement and the questions, I've gone a bit long. This is not permissible under the law, and that is not to be dismissive of the immediate damage that it's causing, but I really think all of us have to not obey in advance. One of the president's innate powers, regardless of whether he's in office or not, this president in particular, is to bluff, is to make things seem inevitable or likely, or having momentum that may or may not be inevitable or likely or having momentum. In this case, what he is proposing is no more powerful than a firmly worded tweet. That is not to say it's not having immediate impact, but in the long run, these statutes govern what we do. All of the authorizing statutes and all the appropriations law are what we have to adhere to. We are still a country of laws. And so I know it's cold comfort when you're trying to operate a school and not knowing whether you're going to be able to literally keep the lights on and make payroll. I understand that. But it is worth saying on the record that the law is the law, and an EO does not get to wave away a federal statute. Senator Cortez Masto.
Thank you. Thank you to the ranking member for his comments, and I thank you all for being here. And let me follow up on that, because there is no doubt that the treaties and laws have consistently acknowledged the federal government's commitment to providing education to American Indian and Alaska Native peoples. But let me start with you, Mr. Dropkick. For the benefit of an administration that does not believe in consultation and does not want to recognize necessarily those treaties and laws, can you talk a little bit about the Department of Education funding like Title I and like IDEA, and how it actually evens the playing field for Native American students, and how cutting this funding could result in Native children, Native communities being left behind?
Yeah, thank you for that question. And definitely when you think about the impact that has, we know obviously the historical context in which educational systems and the government-to-government relationships have continued to be unmet, continue promises made and not kept. And when you continue to create cycles of distrust and unmet promises, it has an impact on communities and in those institutions themselves. So when we have programs and institutions and items that help to validate someone's belief in who they are and the validity of their experience, those programs aren't part of the educational system for our Indian students. Thinking back just to my own experience growing up and being a first-generation college graduate in my family, checking a box for other for my ethnicity. Now I'm glad that we've moved beyond that I'm no longer an other, that I can acknowledge that history. That's a really, that's comforting, but it has an impact on communities. And I didn't get that teaching. I had educational experiences within my public school upbringing that didn't validate those experiences. So by bringing in cultural programming experts and expertise in the situations, you validate not just who they are and who their ancestors are, who their families are, which we know our communities are vital to who we are as people, but then you also repair some of the harm that has been done, that has been purposefully ripped out of communities. And so those programs, without them, then they don't exist, and then you continue to have the negative impacts that we're seeing within educational outcomes, mental health, and then it impacts industry and economics. It's a ripple effect that goes far beyond just the school building.
And thank you. And in your testimony, you say reliable education data remains a challenge due to the small population size of Native students, and the National Indian Education Study remains the most effective tool for collecting disaggregated Native education data and should be preserved. The National Indian Education Study is conducted on behalf of the Department of Education. So could you elaborate on the importance of reliable Native student data collection and how dismantling the Department of Education would create challenges in obtaining that data?
Yeah, absolutely. Part of it is in the relationships and the understanding of the communities that you're serving. And so when you have individuals who are working within the Department of Education in Native serving programs, they have relationships, they have connections, they have ability to be able to make sure that they're getting information, and they understand sometimes what not other mainstream or those that come from a different point of view might not understand in terms of how to collect data meaningfully within tribal communities. Assuming that one size fits all or one measurement is going to give you all the information, others don't have that knowledge of how do we make sure that we're accounting for all of the statistics and numbers in the communities and the areas in which that we need to. So taking away that does take away that information and further creates confusion around the data and how to continue to support it.
And let me, I'm running short on time, but let me touch on something else that is just as important, is the mental health piece of that. And for our students. And Ms. Yellowfish, I'm going to ask you, if you don't mind, after reading your testimony and your discussion around some of the concerns, really the higher than average suicide rates amongst Native youth.
Yes.
And in my time in the Senate, we have worked to get funding, particularly funding for mental health, into our tribal communities, right? And making sure that these issues can be addressed. And given your experience, can you explain the largest barriers in addressing the mental health challenges of Native youth, and actually how the Department of Education funding and what is happening with it right now may help or hurt us reaching our Native youth when it comes to their mental health needs?
I think that with most Indian education programs, priorities are set before us, and these challenges such as suicide and substance abuse, most recent bullying and sexual assault that we have worked with our students, I feel like we are obligated to address these challenges and work with our students and our families as the best that we can. However, the funding resource, the funding ability has not always been adequate to meet those additional needs, because we're doing cultural and curriculum, we're doing languages, we're doing college and career readiness, and these are already objectives in our grants and what we have. And then our priority this year, much more so, is the social emotional well-being of our students and the lack of resources, the lack of funding. However, with partnerships created with the Indian Health Services, tribal communities, that does and may alleviate some of those challenges as far as funding. Ideally, it would be great if we can each have a social worker or a counselor within our Indian education programs to help specifically address those particular situations.
Thank you. And thank you to the chairwoman.
Thank you. I've heard from several of you that some of the important aspects of, for instance, Title VI, and Ms. Yellowfish, you've kind of spoken to this, is the flexibility that comes with it. I think you, Ms. Russell, mentioned that flexibility was key, and I think you, Ms. Rose, when it comes to the tribal colleges, universities. So flexibility is important. It helps address what you have spoken to, Dr. Worrell, which is the ability to shape these programs so that it is responsive to those in the community, in the region, even outside of the school there. There's the discussion with, if we eliminate the Department of Education, what that looks like. Because I think it has been stated, I think it was Senator Smith when she started off her comments, that we have a trust responsibility and regardless of whether you dissolve a department, that responsibility still stays in place. There are many aspects of the programs that we're talking about here today that are required by law. I mean, you cannot get around the requirement, the obligation, the commitment that we have when it comes to funding for those with disabilities. You can't get around your requirement of the Civil Rights Act for enforcement there. And so what we're hearing is that, well, these would be moved to other agencies. And I'm sure that it is true that for instance, under Title VI, you can move that somewhere else, move it to another department. Again, whether we're talking about Department of Justice, maybe some things move to Treasury on the financial assistance side, maybe some things move to Health and Social Services. Can you all weigh in here and speak to what that actually might look like? What that actually might look like if the programs were not eliminated, but housed elsewhere. Are you concerned that you would lose the flexibility? Are you concerned that I think the issue with regards to consultation, because that's a requirement throughout, is one. But if you can share with me and the committee just some of the either the warning signs, the concerns, or perhaps what you might think could even be an advantage moving out from under the Department of Education to another department. Maybe you see none, and that's fair. Tell me why. Because this is what we're talking about up here on the Hill. So share with me your perspectives. Let's start with you, Mr. Topik.
Sure, I won't have a great answer for you, but I'll do my best. I think
I don't think any of us have real concrete
I think that
answers.
the biggest challenge is we don't know what that plan is. And so in order if there was a plan, and I believe everyone here in this room, whether they're here or not, and all the other ones, they want what's best for communities. They want to see students thriving. I've not heard anyone say that they didn't. And they want to increase efficiency. We want to increase efficiency and make sure that money is getting to students and getting to staff and getting to communities. So everyone's on the same page on that. Now, how do we get there? That's where the consultation, that's where the discussions, that's where the developing of a plan, laying out that plan, and then we can address where are the issues. The hard part is that without a plan that has been laid out, we don't even know where to start hypothesizing, where some of those areas might come up. But we do know that we have seen when actions have been taken without that consultation, then unintended consequences are a result. Then services are disrupted. Then staff are accidentally or inappropriately put on leave. Like, those are real consequences that have impact on people, staff, communities that they serve, and organizations. So in terms of looking at what does it look like through tribal consultation and work with the committees in those programs, those discussions could be had. It can have about what does make sense, what are the unintended consequences that we're not seeing, where are the legal ramifications that might come of that. But without that, then everyone's left guessing. And so tribal consultation would be the first part, a plan being laid out. Then we'd be able to address, is there room for growth? Is there room for efficiency? Without a doubt. So let's come together with tribal communities, with those programs that they serve, the institutions that are served, to have those discussions so that we can work on that together.
Let me shift over to you, Ms. Russell, because you mentioned that one of the benefits or the advantages within impact aid and the way it is structured, it again allows for a great deal of flexibility. And it is significant in terms of budgets. I know that in the Iditarod area school district, this is in Southwest Alaska, impact aid makes up about 60% of the funding there. And as Dr. Worrell noted, in Alaska, all of our school districts are very, very worried this fiscal year about their budgets. We also have Secure Rural Schools funding, which impacts many of our smaller communities in the southeastern part, which is impacted by this long-term continuing resolution. So there's a lot of squeeze there. But you mentioned that flexibility allows you to do everything from special ed, transportation, and housing. And Mr. Drupik says, we all want to try to get to the money to the kids, right? Money to the kids. But if you don't have housing for your teachers, you might not have anybody to help your kids. And so speak to me a little bit about the concerns that you might have from where you're sitting with oversight of financially impacted schools.
Right, absolutely. Regarding impact aid specifically, we are concerned because school districts are still waiting on their FY25 appropriations, their payments, to help get them through the end of the school year. And we know that they're already trying to prepare for next school year. I mean, many of the school districts have instituted hiring freezes because they just don't know if they're going to have the money. Are they going to have to put projects on hold? Some projects and programs are being delayed. There's so much uncertainty right now, and not being able to rely on that federal responsibility to these school districts is really concerning. The potential, proposal of moving some programs like Impact Aid, if the Department of Ed were to be dismantled, one issue that we see would be very tough and would lead to delayed payments potentially for years is the fact that there are only 19 dedicated public servants who are expert analysts in the Impact Aid program office who understand this very complicated program. And that staff would need to stay on top of this program to make sure that it continues to be handled in an effective and very efficient manner.
Thank you for that. I was going to ask Ms. Rose a question, but I know that Senator Moran probably has an interest in talking about Haskell.
I'd be educated by hearing your question and their answer about whatever you'd like to ask, Madam Chairman.
I'll give you a break here while you get yourself settled and continue my questions. Let me ask you, Dr. Worrell. ANEP, you have sold me on ANEP years ago, and we have seen the benefits in Alaska and Hawaii. What do you think ANEP loses if it is housed elsewhere? Go ahead and push that button.
Senator, Madam Chair, as you heard from my testimony, I'm a fan of DOE. I'm a fan of the way they operate, the knowledge that they have, the relationships that they have established with Native entities throughout Alaska, and also with our brothers and sisters in Hawaii. They are a known entity to us. They understand education, and they have developed processes where where they are sharing the latest scientific data about various aspects of education. They have meetings where project directors from the different programs are able to come together, and we learn from one another. Senator, I'm just absolutely sold that they have developed the process to work directly with Native people. They hear our concerns, they hear our issues, and they're able to convey that to yourself, to our Congress people, and I think they help influence the directions of educational program. So I would be concerned, that if it were shifted somewhere else, we would, more than likely that's not their expertise. And so there would be a lag, there would be a period where relationships would have to be established, where they would have to gain the knowledge about the complexity and the importance of education. So I'm a fan of the Department of Education for all that they have proven. We just know from our evaluations, our studies, that we are making progress right now. And if it went elsewhere, I would be concerned that we would lose them.
Okay. Senator Moran, we've had a good conversation around the dais today.
Good. Madam Chairwoman, I thank you for being recognized. I've been a member of this committee on and off. Every time there's an opening, I seek to return to the committee, and I'm glad to be back this year. The last time I left, you were mocking me for being the lowest member on the committee.
You're
and I
still a
hope
long
that I
way
am
away.
treated with greater respect than the last time you were chairwoman.
I want you closer to me, Senator Moran.
Good answer. Thank you all very much for being here. I'm going to address this probably to Mr. Dropik and to Ms. Rose, but I want to talk about Haskell University. We have seen significant needs over a long period of time. We've worked hard to help Haskell address those needs. It's been a challenge because of changing leadership. In recent times, we've had no capability, seemingly no capability of getting any assistance from the Bureau of Indian Education. I asked the last Secretary of the Department of Interior for meetings to discuss Haskell numerous times without any success. And the conclusion was that we thought we'd take a different path, or at least test the waters for a different path. And I think Haskell is such a valuable place, such a unique place, such support across the country, somewhat regardless of where I am in the nation traveling. When I'm visiting with tribal leaders, there's always stories about Haskell from them or their family members, and there's a memory and an understanding and appreciation of an asset that, in my view, and I know in yours, needs greater attention. It's the only tribal nations college. It provides Native American students with unique opportunities to pursue tuition-free higher education in an environment that honors and prioritizes Native American heritage and culture. I mentioned the challenges that they have faced. We decided to try a different track. We have released a discussion draft and have been gathering information from the tribal community. And this month, I intend to introduce the Haskell Indian Nations University Improvement Act. This legislation will grant Haskell a federal charter, thereby separating the school from the BIE and entrusting governance to the Haskell Board of Regents, which will be comprised of tribal members nominated by BAA regions. I'm grateful for the support of AIHEC and NIEA in endorsing this legislation. It seems to have broad support from across the country, and certainly all the tribes in Kansas have indicated this is a path forward, and we're going to do everything we can to see that the legislation is passed, but beyond that, and more importantly than that, see that it makes a difference at Haskell University. So I want to outline that because we'd look forward to tribal community support in this legislation, and we'd ask for your help. But I also wanted to ask, with the expertise at this panel, could you speak to the value of passing this legislation, the Haskell Indian Nations University Improvement Act, and separating the university from federal control? Mr. Dropik.
If the senator's okay, I would defer to Ms. Rose to start, being that this is for sure her area of expertise, and I'm happy to join in afterwards. Miigwech, appreciate that.
Thank you. And I'm going to fold in an answer for Chairman Murkowski as well, because her previous question was on flexibility. And that's what your legislation provides, is an opportunity to really think about flexibility. And I want to draw your attention as well to the statement that you made previously about the Department of Interior, because simply moving our Indian education programs from the Department of Education to the Department of Interior and assuming that they have anything or any knowledge of education is a rot decision. I have worked with many secretaries of Interior who were surprised to find out that they have education under their purview. So maintaining our programs at the Department of Ed with expertise is something that would be vitally important. But in specific answer to your question, our board of directors recently passed a motion in March in support of the concept of your legislation, and we were very excited to do so. Our board has talked quite a lot about the benefits that your legislation will provide to Haskell and frankly to the entire TCU community as we work together to support the students and the faculty to ensure that things that just happened, like our staff being frozen or challenges to funding streams because of changes in administration, might not happen. So we stand firmly committed with you and to work with your staff to ensure that the legislation is as strong as it can be, and you have a TCU community that is in full support. So thank you.
Thank you for those statements. As we began, perhaps midway. Sorry, I'm new on the committee. Perhaps midway in our efforts, as we were trying to find ways to improve Haskell, the announcement of layoffs of staff occurred. We think we now have everyone who is not voluntarily left now returned to Haskell, and we're pleased about that outcome. But it is, and I've had a really good conversation with the Secretary of Interior when he, as a North Dakota governor, had experiences with tribes and tribal education, and I'm hoping that we can develop a relationship with the Department of Interior that is helpful in advancing this cause.
We would agree. We do not believe, and from our conversations with the department as well, that letting the staff at Haskell and SIPI was not premeditated, right? It was not part of the plan, and they've been incredibly responsive in ensuring that they made the course correction and turned around and got the staff back. So as soon as we were able to educate them, really let them know what was happening, I think they course corrected quickly and are looking forward to continuing to build and have strong relationships with the institutions. We've also been working with the department in thinking through the legislation. And so I think they're really great partners to stand beside you and ensuring that the legislation is as strong as possible. We do have a couple of recommendations, and we look forward to working with you to strengthen it.
I'm not surprised. Instead of asking just for your support,